Good afternoon. The Appellate Division First Department is now in session. Welcome. I will begin by calling the calendar. People versus Mario Solano is submitted. 2758-2760 LLC is submitted. C. Veronica is submitted. Utica Place versus Chevette. Appellant Utica Place has been given 5 minutes and one in rebuttal. Respondent Chevette, 5 minutes. Feldman versus Port Authority. Appellant Feldman gets 6 minutes and 2 in rebuttal. Port Authority responding gets 6 minutes. Inri Renren Inc. We have a little map here, so let me. Appellant Chow gets 1.5 minutes and plus 0.5 in rebuttal. Appellant Dove Phelps gets 2 minutes and 1 in rebuttal. Petitioner Chen gets 4 minutes and 1 in rebuttal. And Renren Inc. Responding. I'm sorry, Renren Inc. gets 4 minutes and 1 in rebuttal. And then responding Henry Silk gets 7 minutes. I think I got all that right. Tirado versus City of New York. Appellant gets 5 minutes and 1 in rebuttal. Respondent City gets 5 minutes. First American versus Verisk Analytics. Appellant First American gets 6 minutes and 1 in rebuttal. Verisk gets 6 minutes. New York Lawyers versus NYPD. Appellant NYPD gets 6 minutes and 2 in rebuttal. New York Lawyers gets 6 minutes. Diaz versus NYU Langone. Diaz gets 5 minutes and 1 in rebuttal. NYU gets 5. People versus Jamal Johnson. Appellant Johnson gets 5 minutes and 1 in rebuttal. The people get 5 minutes. Cedeno versus Pacelli. Appellant, let's see, both appellant get 3 minutes and 1 in rebuttal each. And then respondent Cedeno will get 5 minutes. People versus Dre. Benjamin Dre, appellant gets 5 minutes and 1 in rebuttal. The people get 5 minutes. Garcia versus Rosario. Appellant Garcia gets 6 minutes and 2 in rebuttal. The respondents, the Rosario respondents gets 5 minutes each. Primis Pacific versus Goldman Sachs. Primis gets 5 minutes and 1 in rebuttal. Respondent gets 5 minutes. I should let you know that Primis Pacific will be the last case call. We have a recusal by Justice Troy Weber, and Justice Jeff Owen has been vouched in. So that case, again, will be called last. Simmons versus Berg. Appellant Berg gets 5 minutes and 1 in rebuttal. Respondent Simmons gets 5. Henry versus New York City Transit is submitted. Newton versus LVMH Moet. Appellant LVMH gets 6 minutes and 2 in rebuttal. Newton gets 6 minutes. Belair and Evans versus Rizzo is submitted. People, X-Rail Turchi versus Wharton. The petitioner gets 5 minutes and 1 in rebuttal. Wharton responding gets 5 minutes. First case on the calendar is Utica Place versus Chevettes.
May it please the court. My name is Kenneth Roberts for Plaintiff Appellant Utica Place. Good afternoon, Your Honors.
Good afternoon.
The essential issue on this appeal is whether the referee should have granted a short continuance of an inquest in the interest of justice pursuant to CPLR 4402, which, as you know, provides, quote, at any time during the trial, the court on motion of any party may order a continuance in the interest of justice, end quote.
Had this matter been adjourned twice before? This is an inquest, right?
Correct, it is an inquest.
Inquests have been adjourned twice.
It had been adjourned twice before. It was marked final, which is why the attorney did not ask for an adjournment and gave it her best shot. But as this court held in Guzman, cited in our brief, and more recently in Global Liberty versus Perez, 168 AD 3rd 592, it is an abuse of discretion to deny a continuance when 4 criteria are met.
Counsel, I'm sorry. You just stated that in response to Justice Acosta's question, you said, yes, it had been marked final, and that's why the attorney did not request a continuance and gave it her best shot. Was she not aware of the fact that it had been marked final?
No. She was aware, which is why when she came in that morning, the attorney who had prepared the case, quote, in sick Sunday night, the night before the Monday morning hearing, this attorney ran down to court Monday morning, knew it was final, and therefore did not ask for an adjournment of the case. She went forward to the best of her ability. When she ran into problems with the evidence, she did ask twice to go off the record and twice for a continuance, and each of the 4 requests were denied by the referee, even though the defendant did not object and could not possibly have been prejudiced.
But counsel,
did she make the referee aware of the fact that that attorney had an emergency and had called in sick the night before, and he stated that he or she was sick the night before?
Unfortunately, she did not. She did say that she needed time to either speak to this witness or obtain. She had available this witness's boss, who could have come down in 2 hours.
So how was the referee to have known as to the reasons why this attorney was unprepared if she did not, tell the referee exactly what had occurred? Given the fact, given the history of the case and the fact that there was this history of them not being ready to proceed.
Well, actually, the history was not being ready to proceed. The case was adjourned twice, not because we weren't ready. The case was adjourned twice because cases get adjourned all the time. This was not marked against us. It was not, there was no history here.
but counsel, didn't the real problem lie with the witness as opposed to with counsel's preparation or lack thereof? Wasn't the witness problematic in the sense that even though he was the plaintiff's project manager, he was dealing with hearsay? He was testifying as to hearsay because he did not prepare the list of expenses and he didn't know who did?
Your Honor, that's what it appears because of the lack of preparation. But the fact is, he was the retail manager. He had the requisite knowledge. The attorney had no time to even speak with him and go over the documents with him before the hearing. And that's why she asked to go off the record and for a short continuance. Look, I've been in similar situations where the judge said, fine, you come back here at 2 p.m. with your witness ready to go or I'm going to dismiss the case. That would have been fine here. We're not talking about prejudice or burden. We're talking about an emergency situation. And I agree she should have, I wish she had said to the judge why she was in that situation, but the fact is she wasn't asking for much.
But I don't know that the attorney necessarily needs to be thrown under the bus. Didn't the project manager also say that he didn't have all the documents evidencing the amount of the expenses he was testifying to?
That is not, first of all, okay, because of the confusion, the lack of preparation, she starts showing him some hearsay documents that of course he had no knowledge of. But what she did show him, what was an exhibit, which would have been admitted if she had been able to prepare him properly, was the actual account, the ledger of this tenant. And that's all that was necessary, was for him to authenticate business records. He did not need personal knowledge. This is an argument that counsel is making, that it was our lack of due diligence. We put on the wrong witness. We put on the right witness. We didn't have time to prepare for his testimony.
This is Judge Gish. I don't really understand this preparation. By the time the morning rolled around, nobody was preparing the witness. You were going into for the hearing. All the preparation would have taken place before the other attorney got sick. Yes? No?
Exactly. With the prior.
So the lack of preparation of the witness can't be thrown at the feet of this woman who filled in. That should have taken place beforehand. Nobody would have expected her to prepare a witness walking in to the inquest.
Look, under no circumstances am I throwing the lawyer under the bus. The fact is that there was no time to communicate between her and the lawyer. There was no time. It wasn't her fault.
Between her and
the lawyer.
I'm sorry?
I'm not laying fault at her.
You're saying
the attorney who had the primary responsibility would have prepared the witness. So this isn't a question of no time to prepare the witness. This sounds like a strategic choice, no?
No, it's not a question of, you're right, preparing is not the right word. It's communicating. She had no time to communicate with this witness, and she asked to go off the record in order to do so and was refused. She asked for.
Why was there not a need for her to communicate with the witness? The witness was there and should have been made aware of what the issues were. So it seems to me that it would have been just not easy, but the witness knew what he or she was to testify to regarding the records. There should have been communication with this witness in the past. So it should have been it should have been simple to simply ask the witness concerning the records.
Under ideal circumstances, you are correct. She simply did not have any time to communicate or even look at the documents herself.
Thank you, Mr. Roberts. Let me hear from respondent.
Yes, good afternoon, Your Honors. Saul Kotze appearing for the respondent, Jason Shavitz. I believe, Your Honors, just listening to some of the comments, I think Your Honors have sort of hit the nail on the head here. First of all,
maybe yes, maybe no. Did you object?
Yes.
At the time, did you say no, don't give an adjournment?
Well, if you look at the transcript, the referee didn't even ask defense counsel. He off the bat objected, but of course, counsel was there, would have objected. The point.
What would have been the basis for the objection, though?
The basis for the objections, Your Honor, it was on for a third time. It had been on twice before. It was on for trial that day. Everybody appeared ready for the trial, prepared. Defendants, I mean, the case got dismissed after plaintiff's presentation of its case in chief, but defendant had, its rebuttals witnesses available outside that day if the case had to go into the defendant's case to put a rebuttal case. But the point was, Your Honor, when
this was on inquest, so you didn't really have a rebuttal. You could contest the amount of damages, but you had a limited role there, right?
It was to contest the damages, but I think some of the issues would have been on damages would have been the market rate of rent. This was a commercial lease, so I believe they did have a witness that may have testified as to what the market rate was around the time in the case, Your Honor. But
money would have been owed. I mean, it seems that the lack of the adjournment really is, or does it create a harsh result, because your client, who was contractually bound to guarantee the rent, is now nothing. They're paying nothing.
Well, he is the guarantor, Your Honor. I believe the main defendants are in bankruptcy. I don't know what's the status of that, and plaintiff is.
Well, that makes it only more harsh, right?
Right. Well, Your Honor, I mean, I think at the end of the day, this really came down to how the plaintiff prepared its case. Just a few facts. counsel and in their brief, they mentioned that there was an attorney who was sick the night before. Going through the papers and the motion papers, there was, first of all, the sick attorney was never identified. At this point, we still don't know who this attorney was. We don't know what the sickness or what the illness was. But even if he did become sick the night before, the case was obviously prepared before that. I doubt that the attorney was going to wake up on Monday morning and start calling people and say, witnesses and say, hey, are you guys available in the next hour to come down to court? The witnesses were obviously lined up early before that. And Mr. Perez, in fact, when he testified with the records that he did try to enter into evidence, he was asked where the records came from, and he said it was plaintiff's counsel gave them to me. So obviously he had communication with the sick attorney. He was given the records from the sick attorney. And the problem was that he was not the custodian of those records. They were all records from outside entities. They were all valid objections. And if plaintiff's position is that they did produce the proper witness, then this appeal should not be based upon a failure to give them an adjournment, but based upon the referee's evidentiary preclusion of the evidence. And that is not what this appeal is about. The referee made all the proper evidentiary rulings. And, basically, and there's law in this, you can't bring in a witness to testify as to the business records of another company.
But a different witness could have been called within a couple of hours, right?
Well, I don't know that because, that was actually never disclosed in the record. When Ms. Mirsky, the attorney that
I heard Mr. Roberts confirm that in oral argument.
Yes.
He said it in oral argument, but if you look at the transcript, Ms. Mirsky never said, I need an hour or I need a day. She asked for a continuance only once she saw that the objections to her records were being sustained. And then finally, at that point, she said, I think there might be another person who can be called. No reason was ever, the name of the person was Anthony Calabrese. Nothing was ever indicated why Mr. Calabrese was not in court that morning, Your Honor. And, at the very start of the hearing, the court asked counsel if she had any other witnesses other than the one witness, Mr. Perez, and she said, no, that's clearly on the transcript on page 15 of the record. So it was, regardless of any illness of any attorney.
Was your client present?
Yes, he was, Your Honor. He was in
You
court.
would have called your client, right?
He was probably going to be called as a witness if the case would have proceeded, yes.
No, but so your client could have been called as an adverse witness and the information gathered from him.
Oh, if plaintiff wanted to strategize his case that way, sure. Another option for plaintiff, Your Honor, under CPLR 3122A, with some foresight, they could have served an affidavit and get a custodian's affidavit to just enter the records in that way. It all really boils down to planning and preparation, and the case was on twice before, so there were options for plaintiff.
Thank you, Mr. Kotze.
Thank you, Your Honor.
Mr. Roberts, you get 1 minute.
Thank you. Custodianship is not a requirement under CPLR 4518. He was not required to be a custodian. This court held in Al Qayyam that any employee with knowledge of the employer's record-keeping practices can authenticate records. That's all that he needed to do. He didn't have to have any personal knowledge. What happened because of the emergency and because of the lack of ability to communicate, they simply didn't get their signals together. They got sidetracked by objections about custodianship and personal knowledge that were irrelevant. There was no personal knowledge necessary to authenticate a business record. You just need to know the business record practices of the employer and whether this record was kept in the ordinary course of business. They just didn't. All she needed was time to speak to her witness and get this together. Instead, what we've got is a miscarriage of justice where the guy walks away from a $450,000 debt that he has never disputed. He's never disputed. And I couldn't put him on the stand and testify to the $450,000. He would just say, I don't know. And so the only way we could do that, and she identified the witness, his boss, the witness's boss, who could come down and we could have gotten this together. And what would have been the burden on the court? What would have been the prejudice on the client? And instead, we've lost $450,000.
Mr. Roberts, if he would have been called and he denies the $400,000 debt, he can be confronted or impeached with the documents that are not being admitted in evidence, right?
That is true. He could have been, but that wouldn't prove our case.
True.
All we'd have is his denial and our impeachment.
Okay, thank you, Mr. Roberts. Thank you both.
Thank you, Your Honors.
Thank you, Your Honors.
Bellman versus Port Authority.
Good afternoon, William Costigan for the appellants. If it please the court, this is an appeal from a 3211 dismissal of 2 cases, each brought by the survivors of a person who jumped off the George Washington Bridge committing suicide.
Mr. Costigan, what is the duty that the Port Authority owes your client?
The duty accrued over time. As they became aware of the increasing number of deaths at their bridge, they had a duty to build a fence that would stop that. The Totoro case, Basso v. Miller, there are any number of cases that correlate the duty to the reasonably foreseeable harm and the burden involved in avoiding that.
So the duty is framed by foreseeability, in effect.
Absolutely.
Right? So
yeah,
so
in
how
Totoro,
was it foreseeable for the Port Authority to feel for it to have a duty to build a higher fence so that folks will not jump from the bridge?
in the 7 years prior to 2016, 93 people that we know of jumped to their deaths from that single bridge. In the next year, at least 12 more that we know of. It is horribly foreseeable. It was horribly foreseeable that more people would jump after if the situation were permitted to continue.
So counsel, looking at the stats this is Judge Gonzalez, looking at the stats that you proffered, you indicated that there were, for example, in 2017, 15 deaths in just in the 2-month period where the 2 tragedies were involved. There were 5 deaths, and that there were 2 deaths a week pretty much. But what do you say to your adversary's argument that, I don't want to be crass, these are voluntary actions undertaken by the unfortunate decedents?
That was the decision of Justice Bluth below in each case, that the decision to commit suicide was an intentional intervening act. Justice Bluth followed the Perloff decision, Justice Sweeney's decision in Kings County. As you are presumably aware, the Second Department reversed that decision. The decision that Justice Bluth relied upon has been reversed. The Second Department decision is at 189 AD 3rd, 1624.
We're familiar.
The answer, Justice Gonzalez, the answer to your question is found in the Totoro case and in Cush, where they both, where the Court of Appeals in each instance holds explicitly that where the intervening act is itself foreseeable, then that will not attenuate the liability of the defendant property owner who has failed to make its premises reasonably safe. So I rely specifically on Totoro and on Cush, and of course the 2 decisions by Judge Hurd, U.S. District Judge applying New York law in the Ginsburg cases, Ginsburg 1 and 2, motion to dismiss and motion on summary judgment.
Could you also contrast the obligations, the varying obligations of the Port Authority when it acts within its governmental authority, and where the special duty relationship applies, and here where you argue that this was basically a proprietor with an obligation to maintain the premises in a reasonable, safe
Yeah.
fashion.
Again, I would turn to the Turturro decision as well as the majority decision in Perloff, as well as the Ginsburg decisions. The drawing on an existing body of precedent, Turturro counsels that it is for the court to look at the specific act or omission that is alleged from which the injury has arisen, and to look at the capacity in which that act or failure of the defendant occurred. Here, our complaint alleges a failure to install anti-suicide fencing. The complaint is about fencing and nothing but fencing. The Port Authority seeks to recharacterize it as an allocation of police resources case. That is not this case. There is not a word in the complaint about police. And as far as the act or omission, here it's the omission to build a fence. The owner of a facility builds a fence. The police don't come and build a fence for you. And it is very much the Port Authority's duty as the owner of that bridge to build that fence, as they eventually did.
Thank you, Mr. Costigan.
Thank you.
Let me hear from the Port Authority.
May it please the court, my name is Cheryl Alterman and I'm representing the defendants respondents, the Port Authority of New York, New Jersey, in these consolidated matters. The decisions and orders below dismissing the complaints were correct and should be affirmed for the following reasons. Government immunity shields government agencies from liability when they're making difficult zero-sum decisions about where and how
Ms.
to deploy.
Ms. Alterman, the problem you have is that in Perlo, the second department found that identical facts that you were acting in a proprietary capacity in the design and maintenance of the bridge. So
Yes, and we've sought
you're subject to ordinary negligence, basically.
Yes, and we believe that that decision was an error and is an outlier, and we've sought immediate relief for leave to appeal to the Court of Appeals, and other government agencies such as the MTA and the City of New York have already filed amicus briefs in support of our position, and we are looking forward to the Court of Appeals correcting that outlier decision, because there's nothing more governmental in nature than protecting human life and suicide.
Can I ask you a question, a procedural question? So Perloff is up at the Court of Appeals?
We've sought leave to appeal to the Court of Appeals.
So the amicus were on the application for leave?
Correct.
Okay.
And that motion is returnable on March 22nd.
So again, tell me why you're not acting in a proprietary capacity. I mean,
yes, absolutely.
The intervention, as Mr. Costigan pointed out, is really not about the use of police resources. In fact, building the fence will prevent you from having more officers, but that's not even the issue, right? The issue is solely the fence, and whether you, as an owner, as someone responsible for the maintenance of the bridge, should do something about it.
By statute, we are operating the George Washington Bridge in a governmental capacity, and the prevention of suicide is a complex public safety issue. That's the essence of a governmental function. The Court of Appeal has told us that we need to look, when we're deciding if the government is acting in a proprietary versus a governmental capacity, there's a continuum, and we need to look at the plaintiff's claim as a whole. We can't parse out simply because the plaintiffs are using words such as foreseeability or that the bridge is a dangerous condition. We have to look what the essence of the claim is here, and the essence of the claim here is stopping intentional wrongful acts, which is a core policing function, and the plaintiffs can't evade the nationally recognized laws that across this country, in Milligan, in Nelson, in the lower courts in this state, have found that bridge operators cannot be held responsible for people deciding to take their own lives and jumping off the bridge. That that's universally held here. Absent a special relationship, there is no duty.
So counsel, just a question. The fence was but waist high?
There's a 4-foot barrier, Your Honor. And so what the plaintiffs did here on the south walkway is that they scale the 4-foot barrier and then unfortunately take their own lives.
So would we be talking, would we be hearing a different set of arguments, for example, if the fence was 10 feet high, as opposed to something that even a small person could scale?
The fence is a mere distraction here. I think we have to take a look at the complaint as a whole. It's no different if you may indulge me for a moment and give you a hypothetical here, is that if someone gets
No, but
mugged,
I gave you the hypothetical.
Yes.
You need to parse that out.
Yes,
because,
absolutely.
Because here you have a history, a protracted history, not of only attempted suicides, but completed suicides. So the stats that were proffered have to do with completed suicides.
Yes, and unfortunately, when there's a will, there's a way. The height of the fence is just a red herring here. It doesn't make a difference. It doesn't change the essence of the allegations here in the complaint. The allegations are for failing to protect the public from harm. And that is a police function. If we look at the actual causes of actions in the complaint, in the record at page 35, it's failure to protect and warn the public. It's failure to not increase the risk of suicide by inaction, to protect human life. This is the claim that the plaintiffs are claiming here, and which is there's nothing more quintessential in government function than policing. And in order to protect people.
Well, isn't it, let me put it another way. This is Judge Gish. So the idea that you keep your property safe, isn't that also just a quintessential function of ownership?
Only if we're talking about ordinary negligence, if we're talking about a pothole in a road and to keep the bridge safe for its intended use. Here it's clear that the decedents were not using the bridge in a reasonable manner for its intended use. This is the world's busiest bridge for the past 85 years. It's a vehicular bridge. It's not intended to be used for people to take their own lives.
So
and
this is Justice Weber. So the fact that individuals did in fact use the bridge to take their own lives or attempt to take their own lives is of no consequence to the extent that it does not impose any type of duty on the Port Authority to do anything. Is that what you're stating?
There's absent a special relationship, there's no duty to protect individuals who commit intentional acts.
So there's no issue as to foreseeability, no issue as to, again, the fact that individuals are continuing to attempt to take their lives or take their lives by jumping off the bridge.
No, because the first question Your Honors have to decide is whether or not there's a duty. And it's our position that there cannot be a duty.
Well, we first have to decide whether you're acting in your governmental role or your proprietary role. If we find that basically you're acting in a proprietary role where basically you have a duty to maintain the bridge, not just fencing, but potholes and everything else that comes with maintaining property.
There's no difference than if we impose liability. If we knew of a high crime rate area and you're saying that the NYPD can be held responsible for every mugging in that neighborhood just because there's a high crime rate, that's the same argument that plaintiffs are making.
No, it isn't. General crime in the city of New York, a city of over 8 million people, is different than obligations in a particular site, in a particular property, in a particular class of folks that will go to that area and commit suicide. I think those are totally different issues, but you've been already almost 8 minutes. So let me hear back from Mr. Costigan and we'll end it.
Very, very briefly, my adversary has raised several factual issues, one of them being the height of the fence. It's not as high as she says. Another of them is being whether determined individuals are going to succeed in committing suicide regardless of what a property owner does. A very controversial claim that she's
Well,
making relative.
she's suggesting that the height of the fence is a red herring, that it doesn't matter whether we're talking about a 4-foot fence or a 6-foot fence or a 10-foot fence, because if individuals wish to jump, they're going to scale the fence regardless of the height of the fence.
There is a body of science. It has a rather grim name, suicidology, and it would say that that is not the case, that suicide's often a fleeting impulse, and it's not that hard to thwart it. The fence is not 4 feet high. It's less than that. The record is basically just the complaint. It describes a low waist-high railing, but I know for a fact it's less than 4 feet. These issues should not be resolved on an appeal of a 3211 dismissal. If anything, even to make the arguments that my adversary is making, there should be a proper factual record.
Thank you, Mr. Costigan.
Thank you.
Thank you both.
Thank you.
Okay, in Renren Inc. Okay, so we've allocated the time for appellant. There are about 3 of you, 4 of you. No, I'm sorry, 3 of you. So who wants to start?
Your Honor, this is Chris Malloy from Skadden Arps for Renren. We agreed that I would start. Some of the issues here regarding jurisdiction overlap, so hopefully we can avoid the duplication. Just very briefly, this is a derivative case brought allegedly on behalf of Renren by non-resident plaintiffs who are bringing the case in their capacity as ordinary holders of ordinary shares of Renren, which is a Cayman Islands company doing business in China. Doesn't do any business in New York.
Yeah, Mr. Malloy,
Sure.
We're talking about substantial connection to New York, right? I mean, the New York Stock Exchange engagement, the IPO, the separation, the private placement, the cash dividends, the use of banking institutions within New York. I mean, this is not even close. So
Your Honor, I can walk through all of those connections, but there's an overarching problem here, and that's that Renren is not the actor in connection with any of the claims here. And the long-arm statute was not designed to and does not provide for a basis for jurisdiction over someone whose actions don't give rise to the claims here.
So who are we talking about then? If it wasn't Renren, then who or what was it?
This is a derivative case where the claims are being brought on Renren's behalf. The other defendants in the case allegedly took actions. The alleged actions were taken that harmed Renren.
But Mr. Chen is the CEO. Mr. Chow is Renren director, right?
They are the defendants in the case. It's their acts that give rise to the cause of action here. Renren is the alleged victim of the causes of action.
Right, he really, in a derivative action, Renren actually stands on the other side. He's a nominal defendant, it's a nominal defendant, correct?
Exactly.
It's got to be named. But as the lower court said, it makes no sense for you to say, oh, they took no actions in connection with the tort. They actually sort of should be looking the other way, shouldn't they? In terms of the actions of the co-defendants and whether they otherwise provide jurisdiction so that Renren, who as a derivative and a derivative action, is the one that stands to gain the remedy.
Well, Your Honor, that's a policy argument that the plaintiffs raised. That Renren, as a nominal defendant, shouldn't be advancing jurisdictional arguments, but that was rejected back in the 30s, Your Honor, when it was held by this court that a derivative of the company and a foreign defendant named in a derivative case, the beneficiary corporation, had to be doing business in the state. There was some rumbling in the dissents and afterwards that left open the possibility that a foreign corporation could be injured by acts of non-resident defendants, and there would be no place where the case could be adjudicated. Long-arm statutes solve that problem. The normal place where you would bring a derivative case is in the place of incorporation or the principal place of business of the corporation. And the
Counsel,
long-arm statutes of that form.
This is Judge Gonzalez. Doesn't the underwriting agreement say that the jurisdiction of any claim that arises out of the agreement is in the U.S. federal, well, in the federal court or in the state court in Manhattan?
This case has, this goes to the question of the adequacy of the contracts. This case has nothing to do with enforcement of the underwriting agreement. The plaintiffs are not party to the underwriting agreement. The claims here are that RenRen's directors damaged RenRen through breaches of fiduciary duty, in a sense, corporate waste. They sold assets for less than they were worth. All of those events took place in China, and they injured RenRen in China. The connections to New York are simply the product of.
It's a little different than that, Mr. Malloy, right? I mean, the idea, I mean, the actual claim is that Chen, together with some of the controlling shareholders, including Mr. Chen, Chow, and DCM, basically orchestrated a transaction to siphon off RenRen's most valuable assets. It's a little different than the way you framed it, right? For their benefit.
That is the claim is that they conspired and they used their positions as corporate officers and directors. It's an internal affairs issue of the corporation. They use those positions to siphon assets of the company away from the company. Those events
through the IPO, through the IPO in New York.
No, the IPO had nothing to do with the claims. The IPO was
Well, the IPO had to do with raising the money that was used to purchase the assets that didn't quite comply with the Investment Act that needed to be put into the special purpose vehicle that were then sold to the I mean, I could go on and on. What I'm really trying to drive at is really, I guess, Judge Acosta's point was that there wasn't just one event at the end here, that there was a continuum of events, at least as alleged in the complaint, that started with the raising of the money in the IPO, that the money wasn't being used for the purpose that it should have been used for or was intended to be used for.
Your Honor, I think what this comes back to is what is the focus in terms of what the relatedness needs to be. The Court of Appeals has said repeatedly that you need to look at the nature of the cause of action and that there has to be some connection with an element of the cause of action. So where RenRen, if RenRen, with the allegation is RenRen borrowed money or raised money on the stock exchange
right.
in 2011, and then years later bought some assets with it, and years after that, sold those assets to insiders for less than they were worth. So if I borrow money from JP Morgan in New York, and then one of my directors, I'm a corporation, steals that money from me in California, there's not jurisdiction in New York because of that, because the elements of the cause of action, the wrongful decision to divert the action, the asset, and the injury that's caused by that would have occurred outside of the jurisdiction.
I think that's really an unfair simplification of exactly what occurred or the allegations as to what occurred in this case. And also, again, we're talking about a 3211 motion. And, you know, it's a little bit more than what you just stated in terms of, you know, borrowing from JP Morgan. Again, as Justice Acosta stated, we have a continuing of transactions, et cetera, that occurred.
I'd like to go back to the point that the long-arm statute, it's clear that if a corporation is headquartered or incorporated in New York, there'd be jurisdiction.
Right, we're not talking about general jurisdiction.
That would be general jurisdiction. So the question is, what did the long-arm statute do? It says a non-domiciliary can be held accountable in New York in a case if it transacts business in New York,
right,
and the claims arise out of that transaction of business. And under the Court of Appeals Kreuter decision, if your corporations always act through agents, so if it's the in-state actions of an agent, they have to be for the benefit of the corporation, not to its detriment. But going back to the first point, transacting business requires purposeful.
But isn't that what's being alleged, Mr. Malloy?
No,
I mean, it's basically siphoning off money by taking Ren's most valuable assets for the benefits of those who are doing it. And those who are doing it, the transactional business, I mean, the ones that are doing it are using every institution in the city to perpetrate.
Their transaction of business can't be attributed to Ren. Because Ren can only act through its agents. Its agents have to be acting for its benefit to attribute those acts to it. And this just goes back to conceptually whether it makes sense to apply the long-arm statute to a company in a derivative case. And it doesn't. Because just going back to the transacting business point, the Court of Appeals has said that requires...
Don't we have to accept the allegations as true at this posture? Isn't that what we held in Wilson versus Dantas?
I think you can. I think you can take them as true. The truth that the allegations taken as true is that Ren's agents acting against its interest conducted transactions in New York that harmed Ren. How does that does not create jurisdiction over Ren. It might create, they have their own arguments that you'll hear as to why it's not sufficient for them, but it can't possibly create jurisdiction over Ren.
Okay, let me hear from the other side. I've given you like 6 minutes, so that's the problem with there's so many of you that it's hard to keep track of the time.
Understood, Your Honor.
Your Honor, Andrew Kratenstein from McDermott, Will and Emery on behalf of Joseph Chen and O Pacific Investment. And just to help with your roadmap, we had been given 4-1 by the court. Thank you. I want to discuss the issue of control. Plaintiffs have failed to plead that Joe Chen exercised sufficient control over the transaction for purposes of establishing either personal jurisdiction over him or plaintiff's derivative standing to bring this case as a whole against any defendant. Plaintiffs allege that the contacts between the transaction in New York can be attributed to Mr. Chen because he was an alleged primary actor behind the transaction, but the transaction was unanimously approved by a special committee of 3 members and the 7-member board of directors.
That Mr. Chen himself control, right? He was the CEO.
That's the allegation, Your Honor.
Well,
but
it's true. Isn't that what 3211 posture is?
No, no. Under CPLR 3016B, when you have alleged breaches of trust, you have to plead with particularity. And when you deal with issues of the independence of directors, and this comes up most commonly in the demand futility context, as the court knows, you have to plead that the directors who made the decision were not in fact independent. There's a long history in this court and in the courts in Delaware as well of a presumption of independence for directors. So it's important to look at each director and determine whether there's been a sufficient allegation on the pleading to challenge their independence. And here
is Mr. Chen the largest voting stockholder?
Yes.
He's the signatory of Ren's IPO, right? Related to the security filing.
I believe he signed the underwriting agreement.
An underwriting agreement, right?
But Your Honor,
isn't he the one who's being alleged to have devised the scheme to defraud Ren and the minority shareholders?
That is correct. But the important point, Your Honor,
is he the one who's alleged to have restructured the transaction to force them to accept the undervalued cash dividends? I
don't think that's accurate, Your Honor. I think
that's what they're alleging.
Well, they allege that he made an offer to buy the assets for a value of $500 million. That transaction then went to a special committee. The board, pursuant to the Articles of Ren, which is a Cayman company, pursuant to those articles, appointed a special committee to assess the transaction, and that special committee hired Duff and Phelps and O'Melveny and Myers to be their advisors, right? And then those 3 special committee members voted unanimously to approve the transaction, and then the board, all 7 of them, voted unanimously to approve the transaction. So you can't just assume Mr. Chen is in control of the transaction when the decision-making authority is delegated pursuant to the articles to a special committee that made a decision. And then you have to look at the board itself, and you have to look at each member and decide
that sounds like a nice factual evaluation that should be left to discovery, not for an argument about whether we have jurisdiction or not.
Well, when we get to, Your Honor, this is very similar to the demand futility cases, which this court deals with all the time and addresses on the pleadings all the time. And we don't see any principled reason why that same jurisprudence doesn't apply here. This court frequently has to assess whether demand is futile. And when it does, it looks at the directors and determines whether they're independent based on the pleading.
It's true enough, but this is a whole different concept of law, and it's not demand futility, it's jurisdiction. It's just plain old jurisdiction. And so you look at it on the pleadings, and it may be what you're saying constitutes a defense here, but I'm not sure why we would do it on a motion to dismiss for lack of jurisdiction.
Well, remember, Your Honor, you have two issues. You have a jurisdictional issue, correct. You also have a standing issue and a demand futility issue. The standing issue and demand futility issue overlap. And this issue of the interestedness or lack thereof of the board goes to both issues. And so that's why we contend that the demand futility standard that this court regularly applies here. Because when you look at the board members, when you look at
the court below in its decision didn't deal with demand futility.
Well, it dealt with standing, and basically the upshot of the standing ruling is that demand was futile.
There was no. Where is it in that underlying? Where is it in those 70 pages of underlying decision? I didn't see anything about demand futility. I know you're arguing that now, but you know,
Your Honor, if you go back to the complaint and read the plaintiff's demand futility allegations, they are based.
I don't have to do that. What I have to do is know what was in front of the court below, and we look at the record below in terms of the motion that was made and the issues raised, and we review it like that. You don't get a de novo review up here. You didn't argue demand futility.
Your Honor, I'm not asking for de novo review. What I'm suggesting is.
And you did not argue demand futility.
We argued lack of standing.
You argued standing, right? Yes. Okay.
We argued lack of standing.
Just want to be clear.
Yes, Your Honor. So we argued lack of standing and we argued lack of jurisdiction, but we believe that the case law that applies
said that. I think we understand. You want us to apply by analogy. We'll see.
Okay, let me hear from the other appellant. Who's next? Duff and Phelps?
Your Honor, it's Adam Slutsky from Goodwin Proctor. I'm going to speak for David Chow and the DCM entities. Just want to spend the 90 seconds that I have focusing on them because they're otherwise sort of an afterthought here. They get lumped together with other parties without any fact allegations that are specifically attributable to them. I think if the lower court's decision stands, then really any outside director voting to approve a challenge transaction would be a primary actor who controlled the transaction for purposes of conferring specific jurisdiction. And for decades, New York courts have required much more. The common thread in all of these cases, as this court put it in 2017 in the Coast to Coast Energy decision, is that the allegations have to sufficiently detail with specific facts the defendant's conduct so as to persuade a court that the defendant was a primary actor in the specific matter in question. As to Mr. Chow and DCM, there are zero specific facts around them to suggest that they were primary actors in this transaction. What we have is plaintiffs going back in time to try to draw inferences from things that happened at RenRen well before the transaction, like RenRen.
Isn't the allegation that or at least is being alleged that it was Chow's investment fund and his control of the stocks of RenRen, and that's why he was rendered a primary actor, or am I misunderstanding that?
I'm not sure, Your Honor. The allegation is that the DCM funds owned around 2% of RenRen, and Mr. Chow personally owned about 0.1% of RenRen.
But he was still standing. He was still stand to benefit, wouldn't he?
Absolutely. And we're not disputing that for purposes of the motion to dismiss on jurisdictional grounds. Benefit is one of the three prongs under the Court of Appeals decision in Kreuter. We're not disputing benefit for purposes of this motion to dismiss. It's control that is lacking in the complaint. And so the allegations as to Mr. Chow and DCM are that before the transaction, things such as RenRen's IPO, they were involved. But there's no allegations of what they did to drive those events. And on top of that, the court was clear in Coast to Coast.
But isn't that what trials are for? What they did?
Maybe as a fact question, Your Honor, but not as to an issue with personal jurisdiction. To hail Mr. Chow and the DCM funds into New York court, plaintiffs have to allege facts specifically about them as to what they did to control this transaction. And all there is in the complaint about them specifically is a lumping together with Mr. Chen about a conduct that about stripping Renren of its assets, but there is no mention how they
did Mr. Chow approve Renren's use of the IPO proceeds to provide capital to Sophie?
After a special committee who consulted with the financial
and the allegation is that a special committee, one is not special and it wasn't independent, right?
The allegation is that it wasn't special because of Mr. Chen, and I'm not here to debate that one way or the other. There are no allegations that Mr. Chow or DCM controlled the special committee. And at the end of, sorry, Your Honor.
Thank you, Mr. Slutsky.
Thank you, Your Honor.
Okay, next.
Your Honor, good afternoon, Your Honors. James Smith, Winston, and Strawn for Appellant Duff and Phelps, and may it please the court. Your Honors, I'm going to address the unique issue to Duff and Phelps of derivative standing under Cayman Island law to sue a third party. And I'm not going to belabor the decision in the Cayman Grand Court case of Top Jet. I think that's very succinctly summarized in Justice Acosta's decision on remitter in Davis versus Scottish Re in footnote 3. Suffice it to say that the parties are in violent agreement that the facts of that case have absolutely nothing to do with what's alleged against Duff and Phelps in this case. And yet, it's the only case that's been cited by either party or the court where derivative standing under Cayman Islands law to sue a third party has been upheld. Now, what plaintiffs focus on in the Top Jet case is dicta that suggests that participating in, being an accessory to, being a party to, or being closely associated with the conduct of the primary wrongdoers that constitutes the fraud on the minority is sufficient to assert derivative standing to sue a third party. What they don't really focus on is the court's analysis of what qualifies there. But I just want to walk your honors through what are the plaintiffs arguing here is the conduct by the primary wrongdoers that constitutes the fraud on the minority. So take a look at their brief on pages 79 and 80 of their brief. They argue first that causing Renren to advance $242 million to SoFi was part of the conduct that constituted the fraud of the minority.
Despite their conflicted positions, right?
Correct.
And the interest in Sophie.
Correct, Your Honor. But on the very next page, they actually affirmatively argue that that conduct predated the formation of the special committee, meaning it predated Duff and Phelps' involvement in this, okay? That's number one. Number two, they say structuring and implementing this so-called scheme, which Your Honors have talked about, supposedly was developed over time. There's no allegation that Duff and Phelps assisted in structuring the scheme. Next, they say it's obtaining kickbacks, and they actually go out of their way on page 82 on that one to say that is unattributable to the special committee, and ergo unattributable.
What about their allegation that Duff and Phelps really was an accessory?
Well, I'm getting to that right now, Your Honor.
Okay, because you're running out of time. That's why I asked.
Okay, I'll go as quickly as I can. Well, here's what it is. What does that leave? Okay, there's not a single factual allegation in the entire complaint that Duff and Phelps ever interacted with the primary defendants at all. All they're alleging is in connection with the board's approval of the transaction, Duff and Phelps gave the special committee an opinion. In paragraph 163 of their complaint, they expressly allege that because that opinion was narrowly drawn and qualified, the board and the special committee could not reasonably rely on it. And that leaves us wondering, what was the participation in the conduct of the primary wrongdoers that constituted the fraud on the minority here? It's not alleged.
Well, Tajet enter, right? The question is whether they either participated or they were accessory to the conduct constituting the relevant breach of duty, right?
I agree, Your Honor. And whether you want to focus on the phrase accessory or participate or party to, Again, we think that's all dicta in Top Jet. Top Jet, the only time it's ever been held, it was a completely different set of facts where the controlling stockholder actually controlled the third party. But put that to the side. There's no accessory conduct here either. Duff and Phelps rendered an opinion that by plaintiff's own allegations, if you look at paragraphs 159, 160 of the complaint, and 163, which I just pointed out, the complaint actually goes to considerable lengths to point out that the opinion on its face was extremely narrowly drawn. It doesn't say the transaction was...
But they also, I mean, the allegation is really that, what was it? That it was reverse engineered to justify the desired price that was given, right?
That's an allegation, Your Honor, but
right. But that's why I keep saying we had a 3211 posture. You folks want us to take all of this stuff as not true when that's not what's required of us. All of those allegations, the re-engineering allegation, the accessory to the conduct allegation, the intentional grossly undervaluing of Renren's assets, that's stuff that we got to take as true.
Your Honor, I would submit that you have to take factual allegations, but not conclusory allegations as true. And I think the only allegations here about Duff and Phelps' conduct that are non-conclusory and factual relate to its opinion and what the opinion constituted and didn't constitute. And I would submit to Your Honors that on its face, it doesn't support accessory participation or party to conduct on Duff and Phelps' part, and there's no standing under Cayman Island law.
Okay, thank you, counsel.
Thank you, Your Honor.
Let me hear from respondent.
Good afternoon, Your Honors. Bill Reed for the respondent. Mr. Chen and Mr. Chow chose to transact business for the first time in 2011 when they came and rang the bell on the New York Stock Exchange at the IPO. And as Justice Barak pointed out, you can draw a straight line from the receipt of those proceeds through New York investment banks to the ultimate second transaction that forms the basis of this claim. That second transaction, the second time that these folks came to New York to do business, involved innumerable New York touch points. And it wasn't just Ren, it was also OPI. In the separation agreement, a number of things had to happen for the ultimate shares of OPI to end up in the singular of Mr. Chen, Mr. Chow, and DCM. We asked the court to infer control based on the fact that these are the people who personally benefited from that second transaction. And to the point, in order to establish New York jurisdiction, we have to establish that that second transaction, quote, relates to our claims. It is the basis for our claim. It couldn't possibly relate more. So let's go through the facts. Ren transferred $134 million to Citibank New York to pay the dividend to the minority shareholders who got forced into this deal. They had to do that because these were ADRs. ADRs, American Depository Receipts, require that the company, in this case Ren, designate a New York agent. That New York agent was Citibank New York. It received the $134 million, which was transferred to DTC Corporation in New York, which paid the dividend. But more to the point, Your Honors, in order for each of the individual defendants, DCM, Chow, and Chen, to get their shares in OPI for themselves, they took the company money, Ren's money, had it sent to New York to pay everyone else, but then they had to deliver an election notice to Skadden's New York office. They had to deliver a waiver of dividend to Skadden New York to pay for their shares of OPI, and they had to pay 5 cents per share to Citi New York, the agent for Ren. That was all pursuant to the separation agreement, an agreement between OPI and Ren, which designated New York law. These are all things they chose. This is all the deliberate action of the defendants. And now, when it was convenient to come here and ring the bell in New York to get their $777 million, now after they stole all the money, over $500 million, according to our allegations, oh, New York all of a sudden has become so inconvenient, we've never heard of it and can't return there ever again. Well, they're asking us to go to China. I'd ask the court to ask them, could you point to a single thing in the record, one thing that actually happened in China relating to these claims? Because the answer is there isn't one. And they also say, well, why don't you go to Cayman? Nothing happened there either. The entire center of gravity of this case is New York. Now, to your Honor's question a moment about this whole demand futility business, it is a required concept in order to establish standing that the plaintiffs under Cayman law have to establish control. I have no better proof of the control that these defendants still have over Wren by Skadden and Narp's appearance here today and taking 5 minutes of this argument to argue to you that Wren should not be a party to this case. Think about it. If this case is successful, Wren will get money and its shareholders will benefit. Why would Wren spend money on Skadden and Arps, who is not cheap, to appear before this court to tell this court that it should not entertain this case? Because, I'll answer the question, they remain in control, which is why they waived the issue in front of Justice Barak. All that we had to do was establish that we had pleaded fraud. We did that in innumerable ways. We pleaded the special committee were a bunch of rubber stamping lackeys. Those are terms used in Cayman law. And the Renovo case to describe the very situation that you have before your honors when it is a case in which people are put forward as a matter of form over substance, which is the language of Renovo, to demonstrate to you that the people that ended up with the money didn't really have the control. But look, we all know who had the control. It's the people who got the $500 million. It's all the defendants before the court. I won't take any more of the court's time. I just ask for you to affirm Justice Barak's thorough and well-reasoned ruling. Thank you.
Thank you, Mr. Reed. Okay, let's get back to rebuttal. Chow. No, I'm sorry. You get 1 minute, Mr. Malloy. You're muted, Mr. Malloy. I'll reset the clock.
Oh, thank you, Your Honor. Your Honor, Mr. Reed's explanation of how Ren is subject to jurisdiction here is somewhat lacking. I mean, basically his argument is, well, Ren's still under control of the wrongdoers, and Skadden shouldn't be here arguing that there's no jurisdiction. But courts have going back to the turn of the last century, the company in a derivative case has been able to challenge jurisdiction. The Supreme Court says that jurisdiction is required.
Well, I thought his point was that you challenge your jurisdiction in a case where you will benefit from the jurisdiction.
Well, that's his
illustrates not to show control.
If he wins, in the meantime, the cost of this litigation is being borne by Ren. We have to, all of the documents and all the witnesses are in China. We have to translate all the documents. That's all cost borne by Ren. And if he loses, we have to pay indemnification to all of the other defendants. So it's not like this is, Ren has the right to have the case litigated in the right form, and this is not the right form. But going back to Justice Gish's comment earlier, that isn't the question of the contacts in a derivative case. Ren is really the beneficiary here. You should look at what the other defendants did. And that's right. There was no acts of Ren that could give rise to jurisdiction. Long-arm jurisdiction has to be determined on a defendant-by-defendant and a claim-by-claim basis.
Yeah, but Ren can only, since it's my comment, Ren can only act through its officers and directors.
Exactly. And in order to bring it into this jurisdiction, those acts have to be done for Ren's benefit. And Mr. Reed explained in detail why all of the acts in New York were taken supposedly by Mr. Chen, Mr. Chow, for their own benefit, not for Ren's benefit, and that damaged Ren. And that's why.
Thank you, Mr. Malloy.
Thank you, Ren.
Okay. 1
Your
minute.
Honor. Yes, Your Honor. I'd like to address two things that Mr. Reed said. The first, he challenged us to name anything that happened in China, and I will name several things that happened in China. All the alleged improper investments that the plaintiffs claim that Ren made after the IPO, that was all done from China. The special committee process was all done in China. The board approval and special committee approval of the transaction, as well as the negotiation of the transaction, was all done in China. So there are a number of things here, and we would say that the center of gravity of this case is either China or the Caymans, where these cases are litigated all the time, and Ren is, again, a Cayman company, as is OPI. So really, this case is about the valuation issue. This case is, they claim that the assets were worth $1 billion instead of $500 million. Okay, where did all of that happen, that valuation? It didn't happen in New York. None of that happened in New York. That's number one. Number two, on the lackey's point, I would just refer to the court to the C-Trip case from the Caymans, where the Grand Court in the Caymans specifically held that the case rested on the tacit assumption, unsupported by any authority, that it's legally impermissible for the chairman of the company to be involved in a going private bid, even if the company's decision to accept or reject the bid was substantially made by independent directors. And that's what we have here. And importantly, to the points made earlier, the court found wholly unmeritorious the bare allegation that directors were lackeys. That's exactly what happened in that case. And Cayman law applies on the standing issue here. We would contend New York applies on the jurisdictional issue, but whether you're applying New York law or Cayman law to the issue of control, we don't think they've met their burden, including on the pleadings under 3016.
Thank you, Mr. Frankenstein. Thank you very much. Mr. Slutsky.
Thank you, Your Honor. Very quickly, I think Mr. Reed's argument is sort of consistent with the complaint here, where Mr. Chow and DCM get lumped in with Mr. Chen as to things that happened going back to 2011, but there are no allegations in the complaint about what they actually did, what steps they took to structure the transaction here. All there is a benefit that DCM and Mr. Chow allegedly received. That's one prong under Kreuter. There's an allegation that Mr. Chow was one of 7 directors who approved this transaction. That's another prong under Kreuter, consent. There's still the third lacking prong, which is control, and there are 0 control allegations.
Thank you, Mr. Slutsky.
Thank you, Your Honor.
32 seconds. That was pretty good.
Yeah.
Thank you, Your Honor.
Your Honor, I'm going to see if I can beat that.
Okay.
Unless I'm mistaken, I don't believe I heard my learned adversary refer to Duff and Phelps once during his entire presentation, and that makes my point more eloquently than anything I could say. So unless Your Honors have any further questions for me, I'm going to rest on my argument and briefs.
Okay, thank you. Thank you, Mr. Smith. Thank you all. Great arguments. Okay, Tirado versus City of New York.
Hello, Your Honor. Rob Rickner for the appellant, Lucille Tirado.
Go ahead.
May it please the court. Eugene Castelli was killed by the negligence of correction officers at the notorious Rikers Island, and his mother sought justice for what happened to her son.
Yeah.
And she was denied it because a notice of claim wasn't filed by prior counsel. Now, the city of New York knew about Mr. Castelli's death. They had an opportunity to investigate. They, in fact, did a thorough investigation. The medical...
I sympathize with you on this case. The problem is, what is the city's obligation? I mean, this is not the traditional case where they lull you into sleeping on your rights, right? They raised the issue of statute of limitation in their answer.
Well, 2 points there. One, this is an issue where they lulled prior counsel into resting on his rights. There were 4 separate court appearances with intensive discovery. And not once did the city ever say, oh, by the way, we're immune from this entire suit. That's an extremely strange position for somebody.
Well, why? Can I ask you a question? Why would they raise it at conferences? They had interposed an answer, and the answer squarely indicated that they denied that the notice of claim had been served. What else were they required to do?
Well, make a motion and say, we don't have to do all this discovery. We don't have to engage in this burden. We're immune. That's effective.
But the time had not run as of yet. When they interposed their answer and they stated that the improper notice of claim, time hadn't run yet. She still had an opportunity to file a notice of claim.
Right. And had prior counsel realized that the notice of claim was missing, I'm sure they would have. I think it's worth looking at these answers.
But then why is that the city's fault? Because prior counsel did not read the answer or recognize or realize the fact that there was some issue with the filing of the notice of claim.
Well, the issue here is that they effectively lulled him it must have become apparent to the city at some point that plaintiff's counsel was litigating as though they had filed a notice of claim and that there was no problem here. And they waited it out. They deliberately waited it out before ever bringing it up, precisely because they knew that would prevent him from ultimately being able to file late.
So counsel, we know that the notice of claim is like the jaws of death, right? You don't comply and you're dead. You're just dead. Are you basically saying that you are required to expend unnecessary time and effort, or are you saying that the city was supposed to help an adversary? Because that's a problem here, isn't it?
Well, it's not that they were supposed to help an adversary. It's that at a certain point, they have to stop acting like that there isn't a problem and stop acting as though that there wasn't, that they weren't immune.
But the problem is that, I mean, I remember when I litigated, you know, the first thing you do is when an answer is interposed, you look at those defenses, you look at counterclaims, you look, you know, I mean, it's not like their answer did not contain a statute of limitation issue in their answer.
Well,
I mean,
if I may, Your Honor, it contained a single numeral, and I think it's worth looking at these answers in context. It's a separate, the city of New York has a completely separate group who produces them. Mr. Himmel, who signed the verification here, as far as I can tell, has signed every verification in every city case I've ever filed, and I mostly sue the city. They contain significant numbers of errors. They don't have interposed responses where it goes through paragraph by paragraph. Some of the things that they got wrong are almost laughable, like denying that my client was dead.
But that begs the question, and in fact, honestly, it really counts against you, knowing that they make mistakes in the answers. Shouldn't you have gone to it and started to do some due diligence to see what's correct and what's not correct there? Quite frankly, had you done that timely, I don't mean you personally, but counsel, that it would have become apparent that there was a problem with the notice of claim.
And look, at a certain point, if the rule is that a single numeral is sufficient to give notice and entirely defeats any equitable possibility for Ms. Tirado to ever get any justice, then that is the end of my case, right? I mean, at a certain point, you have to ask, is the sporting theory of justice really going to be maintained here? Can the city of New York—
Quite frankly, you know, and I like the way you're phrasing it. On the other hand, I think the case is cut against you. Oh, these have been decided.
I don't think that's true. I mean, if you look at the notice provided in, I think it's Scantlebury, in the Court of Claims, that was a full paragraph that would put just about anybody who glanced at it on notice that there was an issue with the notice of claim. That's what the Court of Appeals ruled. What we have here is a mass denial where they list off little paragraphs and you have to put it down next to the complaint and tick it off to see if there is an issue. Now, it's almost as though they designed an answer to provide technical notice without ever accidentally providing actual notice. And that's also how they conducted the litigation. When the prior counsel said, hey, I haven't done a 50H hearing yet. Silence, right? And he goes, oh, great, waiver, instead of realizing that there was an issue, unfortunately. But if we want to allow the city to do this, I lose. But I think that's not equity.
okay.
And I don't think that's what the Court of Appeals wanted.
Thank you, Mr. Rigner. Let me hear from the city.
Good afternoon, Your Honors. Julie Steiner for the respondent, City of New York. I keep dropping, so I hope I don't drop during this argument, and I apologize if I do. The Supreme Court properly dismissed this case, dismissed the complaint for plaintiff's failure to serve.
You litigated this case as if the notice had been filed. Like, what's the story with that? Sort of tricking counsel into thinking that everything was hunky-dory.
Your Honor, the city did not trick the plaintiff at all. This is not a case where we just literally did nothing and then at the last minute decided, aha, and trap him. From the moment that he filed his summons and complaint, within 1 month, we served our answer in which we completely denied that he served, as he called it, a filed and stamped notice of claim. We accurately denied that. And as Your Honor, Your Honor Gish had pointed out, assuming that there were other discrepancies in that answer, there was some due diligence required on the part of plaintiff to discern what was going on. The second point that I like to make is that within, I think, 3 months of her son's death, she sought a 50H hearing when she realized, I never got one. The problem with that argument, Your Honor, is that usually the city would seek a 50H hearing if it had received a notice of claim and had provided a claim number to the plaintiff. And that did not happen here. Again, another example of a situation in which the plaintiff needed to take a look and investigate and look at and review his file.
Counsel, that could have just been the city dropping the ball, because that does not always occur where the city always immediately requests the 50H hearing. Many times it doesn't occur until afterwards when the city realizes that you didn't conduct a 50H hearing. But the point by your adversary was that you attended these conferences. You made discovery requests for medical records, etc. And so you kind of lulled them into the sense that everything was okay in terms of proceeding with the litigation.
Your Honor, we disagree with that assessment or that characterization of what we did. The case law is absolutely clear on this, that the city's participation in pretrial discovery does not bar it from asserting later on that a notice of claim had not been served. And again, I must point you back to that within 1 month of him serving a notice of claim, his summons and complaint, we filed an answer in which we accurately denied receipt. This is not a case where the city did anything, whether it be negligently or deliberately, where we engaged in any misconduct that lulled him into believing that nothing, that the notice of claim was not filed.
Did your response in that answer adequately notify them that your position was that they had not properly filed the notice of claim?
The answer, I think it was paragraph number 4, that he alleged that he filed and served a stamped notice of claim, and our answer flat out denied the allegations in paragraph 4. That is a square, right on the money, hit the head on the nail denial that put him on notice well within the statute of limitations within which to move for leave timely.
And counsel says, if I may.
Yes.
But counsel maintains that all you did was put a number down as opposed to writing it out.
I don't think there's any requirement that we are supposed to write out a word-for-word denial. This is not an affirmative defense, Your Honor. This is a condition precedent that the plaintiff must plead. And he said that that he filed a notice of claim, and that's paragraph number 4. And we denied number 4. That is how answers work. There's no requirement for word denial.
Now, later on, you sent, not you personally, but your office, sent several emails asking for a copy of the stamped notice of claim, but there was no response. Those emails were sent after the statute of limitations expired, right?
Yes, that's correct, Your Honor. But again, the city is under no obligation to make his case out for him. We're not under the obligation to help him prove his condition precedent, because that would eviscerate the law of what a condition precedent is. So the fact that after the statute of limitation expired, we then sought to see what was going on is not misconduct on the part of the city that should warrant equitable estoppel to be applied against it. The city did absolutely everything right now, did everything correct in this matter, including from the get-go denying that it had received a notice of claim in its answer. It was then incumbent upon the plaintiff to do due diligence, discern what was going on,
Thank you, counsel,
and move for leave at that point. Thank you, Your Honor.
Thank you. Okay, you get 1 minute, Mr. Rigner.
Just one last point I'd like to make, Your Honor, which is, and this is a problem with every time somebody tries to seek equity, you can always hold the attorney to a higher level of perfection. It is a downward slope. You will always be able to find and drill down into the one thing that if just the attorney had done that, he was on notice, he would have known, he should have checked his file every quarter, he should have done this. And that creates an impossible situation because it literally writes Bender out of existence. Here it is on the edge, but I think it's on the edge where it tips into Bender territory, where the city's behavior was carefully designed to avoid giving actual notice. This was an affirmative act. I mean, it certainly seems as though it was a plan that was carefully carried out, tiptoeing around the issue until it was too late. And the result is a woman whose son died doesn't get her day in court.
Thank you. Thank you, Mr. Rigner. Thank you both.
Thank you, Your Honor.
First American.
Good afternoon. May it please the court. My name is Darlene Fairman. I'm with the law firm of Herrick Feinstein, here on behalf of plaintiff appellant First American and Interthinks. The motion court erred when it failed to grant summary judgment on First American's ACI claims and dismissing First American's indemnification claims. The motion court made two mistakes in determining that First American didn't prove entitlement to summary judgment with regard to Verisk's failure to disclose the $2.2 million ACI unearned fees liability. First, the court incorrectly held that Section 2.5C of the purchase agreement, the section that required Verisk to provide First American with the financial information to calculate the purchase price, was not breached because it found that the terms of that provision expired 60 days after the closing date. But that finding was wrong as a matter of law because a non-survival clause is a limit on the time in which a breach may occur and not on the time in which a claim can be brought. Here, the breach occurred well within the 60-day time limit, and that's the Case Financial versus Alden case.
Well, isn't the issue that you're both disputing whether a loss may include an overpayment of the purchase price due to a miscalculation?
That's the second error that the court below made. The court's second mistake regarding the ACI claim was finding that there was a question of fact as to whether or not ACI had suffered, as to First American had suffered a loss as a result of Verisk's breaching its representations and warranties. But the loss caused by Verisk's providing incorrect financial information was a $2.2 million overpayment of the purchase price. Verisk failed to reveal a $2.2 million liability. Under the terms of the purchase agreement, that liability should have been subtracted from the purchase price. But because we didn't know about that liability, we couldn't subtract it from the purchase price and therefore overpaid. The motion court was wrong as a matter of law because it relied on parole evidence of what Verisk said the underlying purpose of the purchase price adjustment was and how the parties arrived at that number.
What about defendants' claim that, I mean, they admit that they inadvertently made the mistake, right, of not disclosing the ACI deferred revenue. But they basically are saying that this doesn't really affect the net working capital or otherwise create a loss that's subject to indemnification. So what do you say to that?
Because the only way you can tell that is by going back using parole evidence to say the net working capital that the parties agreed on before executing this contract would have been different but for this liability. And you just can't do that. You can't go back to antecedent negotiations that occurred before the contract to look at what the numbers are in the contract now and say that, well, they would have been different. The court can't do that.
Can they do it to defeat summary judgment?
They can't do it to defeat summary judgment. They can't do it under any circumstances. It's parole evidence. It's inadmissible. You can't look at what was the purpose of this number.
I thought that there are cases that allow parole evidence, in fact, hearsay, to defeat summary judgment. That's my understanding of First Department precedent.
I have no such cases in front of me, and no such cases were cited by the respondent in their briefs.
Okay. Not surprising either. So.
Okay. So the motion court also erred when it said that First American had not presented evidence of costs that it incurred in connection with the ACI liability. First of all, it ignored the fact that a cost that was incurred was an overpayment of the purchase price. Loss under the terms of this contract does not equal cost, first of all, right? Loss is defined as broadly as it could possibly define any loss, damage, claim, etc. It's not just loss, and it certainly isn't cost to complete the work necessary to earn these unearned fees, which is essentially what Verisk is arguing the damages, the
Okay,
cost.
you only got like 30 seconds left. Can you focus on the second course of action?
Yes, the second cause of
Mr.
action with respect to indemnification, the most important thing I'd like to say about that is the court completely ignored the law in the state of New York. The law in the state of New York is set forth in Foyer versus Menkes Foyer, and the case is its progeny. The court doesn't even mention the Foyer case in its decision. The Foyer case is clear. You don't have to have underlying liability or prove it. You just have to have a reasonable settlement, which was true here. Let me also just quickly say the court also erred by ignoring section 9.4 of the purchase agreement, which says that even if a claim is not made in a timely manner, if there's a delay, that doesn't relieve you of your indemnification obligation. So not only did the court ignore Foyer versus Menkes Foyer as if those cases don't even exist, it also ignored section 9.4A of the purchase agreement as if that section doesn't exist.
Thank you. Thank you. Okay. Let me hear from respondents.
Good afternoon, Your Honors. I think it's important first to level set what has been appealed here. With respect to the ACI deferred revenue, we're still awaiting a trial on that issue. All that the motion court did was said that there was a fact issue as to whether a loss, as defined in the purchase agreement, was suffered. Everyone agrees that indemnification in this case would be governed and is governed by Section 9, the indemnification provision, which requires a loss.
That's why I asked the question that basically you make, which is namely that whether a loss has in fact been created. And exactly. I know that you dispute that. That's what trials are for. But what about in the second course of action? I wanted to ask, did you not breach the purchase agreement by rehiring Mr. De Silva? That's admitted, right?
That has been, the motion court ruled that there was a breach. We have not appealed that ruling, at least at this stage, and I'm not contesting it for purposes of this argument.
Okay. Had Justice Owen, when he was at trial court, order you to provide documents relevant to damages resulting from the hiring of Mr. De Silva?
That was our understanding of his discovery ruling. And the issue there is there were discovery requests propounded by the plaintiffs, by the appellants, asking for any documents related to what Mr. De Silva worked on, any revenue producing initiatives, anything of that nature. We produced documents. We put Mr. De Silva up for a deposition. Had the appellants wanted a corporate representative on the issue of Mr. De Silva's work with Verisk, with the respondents.
Are they not entitled to an accounting based on that?
So the language in the purchase agreement does allow for an equitable accounting if there is a breach.
Can I just step in here? It doesn't allow for it. It says you have to give one, right? It's not discretionary. It's the remedy, correct?
It is one of the remedies, Your Honor. The issue here is that nothing is
one of the remedies, right?
I'm sorry, I didn't hear that.
I'm going to agree with you. It's one of the remedies.
Right.
The issue is that it's been provided. Documents have been provided from which
documents aren't an accounting, though. An accounting is something different, isn't it?
I don't believe so in this case, Your Honor.
Isn't an accounting a reconciliation? It may be based on documents, and you may have to provide documents that back up an accounting. Right. But that's not my understanding of an accounting. And accounting is not just providing documents, it's organizing them and reconciling them in an appropriate way relative to the issue that you have to account for.
And
Isn't it?
That actually
Well,
highlights an issue that we have here, because the reason that an equitable accounting is there's a creature of equity, where typically you would have to actually plead for an equitable accounting. You have to plead that there was some sort of special or fiduciary relationship and account over for ill-gotten gains.
Can't you have one for a contract remedy? If a contract provides for an accounting, then that's it. We don't go into fiduciary relationships or not. It's in the contract. Yes? No?
You are correct, and that's why I say here that has already been provided, because what they would be looking at is,
but what you provided pursuant to that's why I asked you the question before, because what you provided pursuant to Justice Owings' discovery order were documents. I think that Justice Gish is saying it's not just documents. I mean, there's no way that plaintiff will be able to look at those documents and determine the circumstances under which he was rehired, what the profits were resulting from that rehiring. I mean, those are things that are not contained in any document. So that's why an accounting is required.
I understand your point, and it's a good point. And the issue there is that what they have asked for is what are the revenues, what are the profits as a result of Mr. Dizillo. They deposed him and were given that information, and the answer is none. Mr. Dizillo is not in a revenue-generating portion of Verisk's business, never has been. He's not someone who goes out and develops business. He doesn't bring in clients. In fact, it's a cost center, effectively, and that's.
I mean, he was valuable enough for the company that he got rehired after the purchase agreement specifically says that it will be a violation to rehire him.
Well, and to go into that issue a little bit, he actually left First American because they stopped doing the work that he wanted to focus on, and he looked elsewhere and then learned that there was an opening at Verisk. The issue with that is that because their damages would be contract damages, i.e. their lost profits, and that's exactly what they told Justice Owing they were seeking, were lost profit damages, not an equitable accounting. They would need to show what it is they lost because he was gone, i.e. what did he work on that maybe First American could have worked on? And the answer was nothing, because they weren't doing anything.
But that really begs the question of whether you provided an accounting. So provide a sworn reconciliation that says nothing, and if it's false, well, you suffer the consequences for it. The contract, to my understanding, says you must.
And I understand that issue. I would simply submit that that's already been done. Mr. Dizillo was deposed and documents were provided, but I understand
that's not an accounting.
It's not.
Okay, thank you, Mr. Haskins. Let me get 1 minute rebuttal.
Thank you, Your Honor. Quickly as possible, the indemnification of the Sager and Weber labor law cases is not something that is still outstanding and we're waiting for trial. Those were outright dismissed because the court didn't apply Foyers versus Menke's Foyers, and that has to be reversed. With respect to why should we have to, we can still go to trial on our losses. Why should we have to spend the money to prove our losses at trial when the loss is a simple mathematical calculation, 155 million minus what they forgot to tell us about, as the contract makes clear what the purchase price should be. And in addition, the court said that section 2.5C.
Well, you say that it's a dollar for dollar.
Correct.
Exchange. I think they dispute that. That's why I mentioned before that that's what trials are for.
But you can't dispute it because it's what the contract says. That's the error that the court made. The contract is clear. It says nothing. You can't look at what would we have said if we had given the correct information. You can't do that. Actually, that's the Coastal Power case. You just can't do that. What the contract says is what you have to live with. And with respect to the accounting, we always sought an accounting. Justice Owing said we'd get the accounting if we proved it.
We got that. Thank
you.
Thank
you all so much. I appreciate it.
Bye-bye. Diaz versus NYU. I'm sorry.
Yes.
That is New York lawyers versus NYPD. I apologize.
Good afternoon. May it please the court, Lorenzo De Silvio on behalf of the police department. This court can and should modify Supreme Court's order to permit the police department to make the redactions that is proposed and which Nalpi has seen. But I'd like to be upfront with the court about something here. The way that the police department litigated its redactions argument, it could have been and likely should have been different. But the fact remains that the issue of body and blood spatter was squarely presented in this case. At the administrative level, the police department denied Nalpi's request for unredacted copies of the body-worn camera footage, invoking the privacy exemption. And in Supreme Court, it explained that the footage includes images of Ms. Muller's body and blood spatter, which, to avoid an unwarranted invasion of personal privacy.
But why wasn't that raised from the get-go? Because that is odd to me, the posture of this case, where I mean, I have the plaintiffs here disputing really whether Mueller's family has an interest in protecting her dignity by limiting public access to images of her bloody body. I mean, like, am I missing something here?
A couple of responses, Your Honor. First, Nalpi did litigate that issue, so that they did have a fair opportunity to litigate that. Second of all, just as a reminder, we've only appealed on the redactions issue, but primarily we refused to disclose the footage on the basis that there were ongoing investigations at the time of the FOIL request and the time of the FOIL petition. But I get what Your Honor's saying that, well, why didn't they do this from the get-go? But I would turn to merits. On the merits, the balance tips in favor of redacting images of Ms. Muller's body and blood spatter here, because a reasonable person expects that images of their loved one's death won't be disclosed unless they say that that's okay. And that follows from the FDNY decision and also FOIL itself, because there can be no unwarranted invasion of personal privacy if consent is given. Consent is the touchstone. Nalpi's contrary approach would run roughshod over the privacy interests that the agency invoked here, because they're—
Counsel, this is Judge Gonzalez. Let's say we agree with you. What about the privacy interests of the passersby? Why is that an issue? So people who walk on the street are walking in public. People who are walking on the street are subject to whatever cameras they are, be they business cameras that are, that's not the right way to put it, but you know what I mean. Business surveillance cameras that are set up. Why is the privacy interest? Why are the privacy interests of the passersby subject to our consideration here?
Justice Gonzalez, two answers. The first is that there is a difference between if I'm in the park and I'm taking a video and I capture someone behind the thing I'm taking a video of, and the state capturing a video on body-worn camera footage. It's also the case that these images would be forever associated with footage on which you can hear the fatal shooting of someone. And these are people who are outside Ms. Muller's apartment after the shooting and are totally unconnected to the incident at issue. And I think the final point I would say about the third-party faces is that, you know, other than waiver and preservation issues, I've never heard Nalpi articulate what it is about not hearing, say, Ms. Muller's address or seeing these faces would affect the public's ability to understand police officer interactions with those.
So you're bringing the address in, but the address of the address was publicly promulgated or visible, right? Because this was something that was in the news, in print, and so on.
It wasn't news articles. Our argument is threefold, that you can limit channels just because a piece of information is available in some other form. And also the fact that it really cuts both ways, because if the address has already been disclosed, then why does it need to be disclosed here? The last point I want to make is—
Counsel, before you do that, I just want to back up for a second. Was it not your position that you needed the consent, or at least that the family should be asked whether or not they would consent or not consent to blurring out the face of the deceased? Wasn't that your argument at some point in time?
That is our argument, Your Honor. And here's where the rub is. It's that our position is that it's better to redact the images unless and until the next of kin consents, because a redaction can always be removed if, as NALPI did in the NALPI 1 case, they get Ms. Muller's next of kin's consent. But the inverse isn't true because the cat's out of the bag if, as they say, in the time to respond to a FOIL request, if you can't identify the next of kin and confirm that they don't want these images released, too bad, you have to release the footage without any redactions. And that, we think, is untenable.
Okay. Thank you. Thank you, Mr. Silvio.
Thank you, Your Honor.
Let me hear from respondent in this case.
Good afternoon, Your Honors. My name is Benjamin Reed from Millbank. I'm pro bono counsel for the petitioner respondent in this case, New York Lawyers for the Public Interest. I really want to—
Counsel, I don't understand. Why would it be in the public interest to see the face of the deceased, to see the gory scene, to see the blood splatters, etc.? Why is that for the good of the public interest?
So, Your Honor, basically, the way I'd characterize it, the public interest is in understanding exactly what happened, and especially understanding what officers did and how they behaved.
So how does this assist the public in understanding what happened? Why do we need to see the face? Why do we need to see the blood splatters? Why do we need to see this gory scene in order to understand what occurred?
So to answer by example, the other case we had, which we refer to in the papers as Dilpe versus NYPD 1, really squarely addressed this exact issue. The NYPD had made the exact same argument. Basically, we can provide all the footage up to and including the shooting, but anything that happens, in the immediate aftermath, we need to redact because it includes.
Counsel, your argument begs the question. You're really not answering the question. Why does blood and gore? Why does blood and gore have to be?
Let me go to the chase, Mr. Reed. The New York Times case talks about the balancing between your countervailing public interest and the family need to preserve the dignity of their loved ones, right? So that's by basically not showing the video footage of her dead body, splatter, right, and all of that stuff that has been mentioned. So why isn't the balancing that we do necessary to blur that?
The issue is it's never just the body, because you have officers that have just shot somebody after entering the home, and then they immediately rush to that person, and you have this hectic, chaotic scene often where officers are interacting with the person, they're handcuffing the person.
But you can get that. In my hypothetical, you can get that by just blurring her face.
But so the position that the NYPD takes is we have to blur, the person's entire body. Any blood that's on the wall is blurred. So when you look at the footage, sometimes you can't see anything and can't discern what's actually taking place. And that's exactly what the court had found in Dilpe 1.
That's the problem, that this court, we've gotten, just in the last month, perfected dozens of these cases related to FOIL and body cameras. And I wish that they weren't so overbroad, but I also wish the other side was not so inquisitive as to require all of this gory information that really affront somebody's dignity. Someone getting shot and blood splatter. I don't know how the public should go over what Justice Gish said, benefit from something like that. What is that was Justice Weber.
I would have said it though.
How would so how would the public will benefit from that? There got to be rational argument being made by both sides. And I think the New York Times case, perfectly illustrates the balancing. That's a Court of Appeals giving guidance, at least as of 2005, about the balancing of both interests. And people have to be rational about this.
And the balancing is extremely important. And certainly, if it's just the case that you have, a gory image of somebody in the corner of a room, the public interest is not going to be as high there. When you have, somebody shooting a person and then providing what they call medical treatment to that person, that's something after a deadly police shooting, there's a very significant interest in. The court recognized it as
Right.
like an
This
interest of the
is
utmost
Judge
importance.
Bushnell, which I think brings up the point, and it's consistent really with what we're all talking about, which is that the balancing may change from case to case. You can't make a broad pronouncement of this, but you can generally provide, say, for the privacy on balance, let's blur out the dead body or the identity or the blood, and have the trial court look at it and see if it's going to meet the needs of balancing on the other side in a particular case, rather than just a blanket rule here, a blanket ruling. No, you get everything.
Well, and part of the problem is that the NYPD never came forward with any sort of factual showing. There was never.
And that's a problem.
That's a problem. Okay. Thank you, Mr. Reed. Mr. De Silvio?
I'd like to make one quick point in addition to answering any questions that the panel has, Your Honors. I'd just like to underscore that NLP has the footage with the redactions that the NYPD has proposed. It's about 30 minutes of footage taken from 3 officers. They speculate that there's something that the public needs to see, notwithstanding the redactions of the body and blood spatter. They can and should address those arguments on remand regarding the scope and duration of the redactions, likely assisted with the footage that they have. And I'd also just underscore that you can hear everything the officers are saying after Ms. Mueller is shot. So there's really no issue there. It's just fancy body and blood spatter. And we submit the balance tips in favor of that limited redaction to the 30 minutes of footage.
Okay. Thank you both.
Thank you.
Sorry for the impatience, but Diaz versus NYU.
Good afternoon, Your Honors. My name is Mitchell Giddin for the appellant. We submit that there's a fact issue on when serratia was first present in the infant's bloodstream. And we say that based on Dr. Karsden, the plaintiff's expert neonatologist, who noted that abscesses from serratia take a minimum of 8 days from seeding the brain tissue or brain parenchyma. And before that is a stage of cerebritis. Now, he didn't define every term he used, but he did use the terms that support his opinion, that is Dr. Karsden's opinion, based on the record. We say that the judge, the trial judge or the motion judge, Judge Rackower, really found the defendant's argument based on Dr. Laurie, the expert that was an expert in infectious diseases, found his explanations more plausible. So I just wanted to run through a couple of reasons why we say that we're equally plausible, and that's a fact issue. For one thing, Dr. Karsden explains that the signs and symptoms of infection in a neonate can be subtle, and he disputes the opinion by Dr. Rubin that, the infant would have to decompensate very severely within no more than 48 hours after a bloodstream, after there's any amount of serratia bacteria in the blood. The 8 days from seeding to abscess is completely consistent with the abscess originating about the time of when the baby did become acutely ill on the 25th of January. The defense sort of slides over the timing and by insisting that the abscesses were present on the 30th. That's all based on neuroimaging, first ultrasound on the 30th, and then on the 31st, an MRI that showed abscesses. But prior to the baby becoming seriously ill, I think the date was January 12th, there was a normal head ultrasound. So, when you see an abscess on ultrasound, it doesn't mean it was there just hours before. It certainly could have been there. It's totally consistent with the timeline that it was present at the time the baby became so acutely ill on the 25th. Dr. Rubin for the defense first talks about the timing of forming of abscesses in his reply papers that we and myself at oral argument did the best I could to explain, where it got a bit tricky to.
But you argue that Dr. Kars don't disagree with that, right?
Disagree with what, Judge?
Disagree with whether there was a deviation. I mean, whether a workup was necessary to begin with earlier than the 25th when symptoms.
No, we do. That's why this is on causation. The judge didn't say anything about departure. With respect to the infection was detectable as on the 16th of January when the first abnormal white count was detected, and that
so there was January 16 or 16 is when you saw the excess white blood cells, right, which indicate an infection.
You saw the abnormal immature to total neutrophils, and that's just the beginning of the inflammatory response. But I think what's key is there is circumstantial evidence, if you'll call it that, and the defendants had no response to this, that on the 16th, there was a plan to take another CBC in a week's time. Yet they repeated the CBC. Why would they repeat it the next day if the 16th was completely normal? They repeated it the next day because the residents said we should take out the PICC line because it can be a source of infection. And the PICC line doesn't cause infection just when it's inserted, as Dr. Rubin sort of implied in an argumentative way. It becomes a portal for infection, and that's why they're taken out after 10 days. And that's why I say in circumstantial evidence, they repeat the CBC the very next day. This is not.
So you're a doctor, though. One of the things your doctor said is that when they were doing those blood tests, they weren't getting normal blood results back. And that information, as I understand it, he thought it was a deviation not to do a sepsis workup on the 16th and the 17th, which would have revealed the infection.
Correct.
Because that was, even though the infection may have otherwise been asymptomatic, it was within the 8 to 10 day period that your doctor said that this was brewing.
Yeah, so we say that, and he just disputes that the clinical, defendant can always say, oh, it's the clinical picture, with the suggestion that looking at the record you can't appreciate the full clinical picture. But if Dr. Carsden is correct, he insists that the laboratories are at least as important as the clinical picture, and
counsel,
the sepsis workup is not so elaborate. All they had to.
Counsel, if I may.
Yes.
Isn't there an issue that's presented that could be considered as an issue of fact as competing experts with respect to the CBC results on the 16th that were elevated, that then went down on the 17th, sometimes precipitously, and that were supposedly remedied through an antibiotic course of treatment.
Right. Well, I think that's what hung up the lower court. Said that these abnormal labs would not right themselves in the absence of antibiotics. Antibiotics were started after the baby was acutely ill, just early in the morning on the 26th. The baby.
And your doctor says that this isn't evidence of a resolution so much as lays open or the possibility that the bacteria was seeding itself in the brain.
Yes, because it's I don't know if I want to say it's typical, but it certainly explains that it's not. You can't assume that just because you had a normal blood count on the 23rd that there was never any infection present. To believe what Dr. or accept what Dr. Rubin is saying is the infection had to start after that abnormal blood count on the 23rd and be so severe within 2 days. Now, that's his opinion. But Dr. Carsden very plausibly explains that there's a start of an inflammatory response where there's increased white cells. They're used up. You can see when the absolute neutrophil count drops, that's because those neutrophils are attacking whatever serrations in the bloodstream.
Okay.
And
Thank you, Mr. Gidding. Let me hear from NYU.
Am I on? Good afternoon, Your Honors. Deirdre Tracy from Aronson, Rappaport, Feinstein, and Deutsch. So everyone here is in agreement that this was an extremely premature infant who had an equally immature immune system. And plaintiff and their expert also agree with our expert that part of that immature immune system is that there's wide variability with the labs, which is why our expert, in meeting the prima facie burden that NYU is entitled to judgment as a matter of law, assessed the propriety of NYU's care based on the facts as they were when they were treating this infant. So when we look to January 16th, when the infant was just over 2 weeks old, what plaintiff points to is one elevated band count. It was mildly elevated, and because there's variability with infants such as the plaintiff in this case, what happened was the next day, another CBC was taken. The next day, the band count was no longer elevated. On that date, however, there was a slightly depressed absolute neutrophils, but as Dr. Rubin points out and explains, that's also not indicative of an infection, because in addition to the absolute neutrophil count, we have to look at the entire picture of all of the facts as they're treating the infant. That included within the blood work that there was also the leukocyte count and the platelet count that in conjunction with the absolute neutrophils didn't indicate infection. In addition, this entire time period, this infant was clinically stable or satisfactory within the context of her being extremely premature.
But what do we do with Dr. Carsden? I mean, Dr. Carsden really disagrees with you on that issue, right? Even on whether there was a deviation from good and accepted medical practice when no sepsis workup was done in response to the elevated immature total neutrophil ratio that was observed on the 16th.
Well, right. So the count on the 16th writes it on the 17th. And the disagreement comes from that Dr. Rubin explains how Serratia, the particular type of infection here, is very fast acting. So when it's infecting an extremely premature infant who's under 3 pounds, it overwhelms the immune system very quickly.
But counsel, don't you have a disagreement here as to whether Serratia barkasens manifests itself very quickly or whether it incubates? And doesn't that present an issue of fact that a jury has to consider?
No, Your Honor, it doesn't create an issue of fact because it's not a disagreement as to Serratia. In fact, Dr. Carsden never actually addresses Serratia or what Dr. Rubin explained.
Dr. Carsden says that the Serratia would have been discovered certainly before the respiratory distress of the January 25th, had you done the sepsis workup initially on the 16th.
Precisely, and that's what we also explicated in our brief, is that he's starting from the after acquired knowledge that the infant had Serratia and developed these brain abscesses and working back. There's no mention, there's no rebuttal to Dr. Rubin's opinion as to Serratia being fast acting. There's no rebuttal as to Dr. Rubin's.
That. I read the expert affidavits here, and he talked about an incubation period of 8 to 10 days. That's different than what your doctor said. I think, certainly for me, there's no question your doctor made a prima facie case, and a jury may find your doctor was correct. What I am having a little trouble understanding is why we are just discounting the plaintiff's doctor and what they say when in fact, I think he does address issues right on the head.
So, Your Honor, I'd like to point that. So it's not discounting him. And that's where a plaintiff misstates what the court below did. It's that plaintiff's expert himself on page 751 of the record, he starts with the head ultrasounds of January 30th and 31st. And then that's where he works back from that. And as this court knows, it's not hindsight reasoning that can raise a triable issue.
I disagree with that too, because he talks about what he talks about, because we all know that that's what the baby was ultimately diagnosed with. And certainly the tests are what they are. But he goes back to the 16th and the 17th, and he looks at the symptomatology. And in fact, he acknowledges that the bacteria that the child had would not necessarily have been expressly symptomatic at that time, but there was enough to do a sepsis workup for whatever bacteria was there, and it would have revealed the disease we're talking about. That's how I understood the affidavit. What did I miss?
So first, the first thing is, and as again, we're going to say that it is working back from the later known knowledge. However, when you look at the 16th, and the very next day, that band count is normal again. What he then points to on the 17th is something that's not indicative of an infection. And he doesn't rebut any of the opinion of Dr. Rubin, where he discusses the leukocytes, the platelets, and nowhere in Dr. Carsden's opinion at all is there any discussion as to the clinical status of the infant during this entire time period, when we're talking about a 2.5 pound, if
So
that.
Let's talk about, for 1 second, counsel, the clinical presentation that's presented by this preemie. All right. So one doctor says, all I have to do is look at how the baby presents clinically, and the other doctor says, no, you can be sick and not show any symptoms outwardly. I mean, we're all familiar with that, aren't we? Aren't we familiar with infections right now? Aren't we familiar with infections that incubate? And doesn't this always present an issue of fact? You're talking about etiology. What's the genesis of the infection that manifests on the 25th?
I'm trying to go back to the first part of it. So you're talking about
the clinical presentation.
Okay, so that's what the first point I wanted to address.
Distinction here. There's
right. So what I wanted to, there's actually not a disagreement. That was actually what plaintiff is faulting the defendants for only focusing on the clinical presentation to the exclusion of the lab values, when that's not what happened. And the opposite is actually what's occurring, where it is the plaintiff who's excluding the clinical presentation ignoring the clinical presentation, and only focusing on these two very discrete lab values. And again, that doesn't come from looking at them, where we've already acknowledged that there's wide variability with these lab values. So it doesn't come from assessing the lab values at the time. It comes from later on and later on during infection, as it shows in our brief, the band count is even higher. Like those lab values are even further out of whack. So and again, it also goes to, yes, Your Honor?
I'll give you 10 seconds to finish up. I'm sorry. It's
okay. No, thank you, Your Honor. But then on that point, I just want to point out that, again, as you said, we made our prima facie case, and plaintiff's expert, instead of assessing the propriety of the care at the time, is using hindsight reasoning and failed to rebut very specific points to Dr. Rubin's opinion.
Thank you. Okay, you get 1 minute, Mr. Gritton.
Yeah, thank you, Judge. We're not arguing that the lab values on the 16th and 17th are quote unquote indicative of infection. There's sufficient to trigger a culture. And based on the timeline of when the baby became sick and the timeline of when the abscesses developed, et cetera, that it fits very well with Dr. Carsden's explanation. I think the defendant's position before the trial court in their papers, they're arguing a summation in a trial, and obviously that's not what we're here for. There's a time from bacteremia to invading passing the blood-brain barrier to creating cerebritis and then resulting ultimately in abscess. I think it's a pretty stark difference of opinion, and every time defense counsel's asked Why is it not a simple difference of opinion? There's a retreat to, essentially, it's more plausible, it's more persuasive what Dr. Rubin's saying. We know that's not the test. Thank you,
Okay.
Judge.
Thank you. Thank you both. People versus Johnson.
May I begin, Your Honor?
You may, Mr. Greenberg.
Thank you, Your Honor. Simon Greenberg for Appellant Jamal Johnson. Because I only have 5 minutes for my argument, I would like to begin with point 2, unless the bench would like me to address point 1 first.
You can begin any way you want to, Mr. Greenberg.
Thank you, Your Honor. The hearing court abused or improvidently exercised discretion when it denied defense counsel's motion to adjourn the hearing to permit Mr. Johnson to appear at the SORA hearing after his release from prison. And there are 4 factors that strongly weighed in favor of an adjournment, none of which the court actually considered. And so the first factor is that while we acknowledge that the community has a legitimate interest in being protected from people who committed sex offenses, that there was an adjournment in this case would not have endangered the community at all.
So counsel, the defendant waived the right to appear at his SORA hearing 3 times, right?
I believe.
And what he wanted to do was appear post-release. His big thing was, I'm not appearing in shackles. I don't want to go to a SORA hearing before release. So my question to you is there a right, is there an entitlement to a hearing post-release?
Thank you, Your Honor. There is a right to, I don't think there's specifically a right to a hearing in every case post-release, but in the there is a right to appear at your SORA hearing, which I understand is not an unlimited right, but under the circumstances of this case, it was an abuse of discretion not to permit Mr. Johnson to appear at the SORA hearing after his release. And the statute itself does not forbid a SORA hearing from occurring after release.
Well, I'm sorry, counsel, I'm confused. I thought the issue was that the day of the SORA hearing, that he had sent letters to the court and to his counsel stating that he did not wish to appear at the hearing in shackles. And that actually, to some extent, I guess he's requesting that the hearing be held the day after, which would have been when he was to be released. Is that not the issue?
That is, well, yes, that is the issue, but that is what Mr. Johnson wanted to do. The issue is whether it was an abuse of discretion or an improvident exercise of discretion to deny defense counsel's request made on the date that the hearing was actually completed to adjourn the case until the next week, in large part because of what Mr. Johnson wanted to do.
When he would be,
Yeah, but why is that? This is Judge. Sorry.
I apologize.
No, it's me.
At liberty, right? That was the whole point. Would he not have been at liberty when the case would have been adjourned?
He would, yes, Your Honor. He would have been at liberty at the time that he wanted to appear for the SORA hearing. That is correct.
In order for it to be an abuse of discretion, to deny, doesn't the person asking for the adjournment have to have a legitimate reason?
I hear, Your Honor, the legitimate reason for I don't think that, I think that.
So let's start easy. The answer to that is yes, right? So what was the legitimate reason here? What was his reason? And why was that legitimate?
I disagree, Your Honor, that in order to obtain an adjournment, that a defendant needs to have a legitimate reason.
No, it's the opposite. In order to deny an adjournment or in order to grant an adjournment, that is discretionary. So the question becomes, why when the judge denied the request for an adjournment, why was that an abuse of his discretion?
I totally and completely agree with you, Your Honor. The issue
Okay,
is,
so why would it have been an abuse of discretion to deny the adjournment based upon the defendant's statements that he wanted an adjournment simply because he did not wish to appear at the hearing in shackles?
because, Your Honor, the issue is his right to be present, and the court was required not just to consider whether his reason for not wanting to appear until after he got out was legitimate. It was whether due process gave him, the factors that are relevant to due process weighed in favor of, excusing the fact that he did not have a legitimate reason for coming, but recognizing the overwhelming importance of giving someone, permitting someone who wants to appear in court to appear and have their day in court. And the issue here is that, as I was saying at the beginning, Your Honor, there are 4 factors that strongly weigh in favor of granting an adjournment here.
I'll give you 30 seconds to go over them, Mr. Greenberg.
Okay. Well, okay, Your Honor. The 4 factors are that there would not have been any endangerment to the community if the hearing had been adjourned until after Mr. Johnson's release, because the correction law still would have required Mr. Johnson to register before his release from prison, even if he didn't have the SORA hearing completed until after. There also would have only been a few days delay in assigning him a community notification level. So that's one factor, is the lack of any risk to the community. The second factor that strongly weighs in favor of an adjournment here is that Mr. Johnson made it abundantly clear through a letter to the court and through counsel's statements during the adjournment request that he wanted to appear. He had something to say. And we don't dispute that he waived his right to appear at that time, but the case law, especially case law like Parker from the criminal context, says that a knowing and valid waiver is not the end of the matter. The court has to further exercise discretion by analyzing specific factors that are necessary to weigh the importance of giving the person another opportunity to appear. And so the third factor here is that rescheduling would not have been difficult at all. It's
taking you a lot more than 30 seconds, Mr. Greenberg. I tell you what, I'll give you an extra 30 seconds in the photo. Let us first hear from the DA, Mr. McClellan.
Thank you, Your Honor. May it please the court, Robert McIver on behalf of the Bronx County District Attorney's Office. The defendant's qualifying sex offense meant that the SORA court was required to adjudicate his sex offense level. His current challenge to the underlying plea is not properly before this court, and he's failed to demonstrate any reliance on the misstatement or that he was otherwise prejudiced. With respect to the adjournment issue, I'd like to answer Judge Gonzalez's initial question. The court only has to afford the defendant an opportunity to appear under People v. Brooks, and that's quoted on page 29 of our opinion. I disagree with the analogy to Parker. This is a case about just affording him an opportunity. And defendant here was trying to condition his appearance so that he could be at liberty at the time. The court was entitled to reject that, and the court had also was allowed to consider the fact that defendant executed not just he had actually executed a written waiver of his right to be present. So all of those factors read together support the exercise of the court's discretion. I am happy to address the underlying merits. I'm also happy to rest on my brief if there are no questions for me.
I think we're good. Thank you, Mr. McIver. I'll give you 1 minute, Mr. Greenberg.
Okay, thank you, Your Honor. We disagree that the only issue here is whether the court was required to give Mr. Johnson an opportunity to appear. The statute correction law says that he has that's the statutory requirement, but we're dealing here with due process and the due process right to appear at the SORA hearing. Brooks, when it refers to the opportunity to appear, is merely quoting the statute, but then it goes on to say that it will use the same standard that applies in a criminal context to determine whether, even after finding a knowing and valid waiver, it is still an abuse of discretion to not give the defendant one more chance to appear. And in that context, it doesn't matter if the defendant lacks a valid reason for not coming to court to show up for his criminal trial. The question is, does due process require the court to give the defendant another opportunity to be present at trial, which is obviously one of the most sacred rights in all of the legal system. And here, because of the importance of being present to the argument that defense counsel made on Mr. Johnson's part, the downward departure argument, which had to do with his remorse, the fact that he changed as a person while in prison, the best evidence in support of that argument would have been his own statement in person, where the judge could determine his credibility. Instead, the court made a credibility determination against him, saying he was incredible, that he was disingenuous, and all of this without giving Mr. Johnson the chance to respond to that and say, you know, Judge, no, I really do feel sorry for what I did, and I have changed. And so the issue is not whether the shackles were a legitimate reason not to come to court. It's whether, even if there was a valid waiver of his right to appear, due process required the court to be a little more careful in out of hand rejecting the request for an adjournment when being present was very important to Mr. Johnson. He made it extremely clear to the court how important it was, and there would have been no prejudice to the people whatsoever if there had just been an adjournment of a few days. And this really,
you know, counsel, there had been 2 adjournments. I don't want to cut into your time, but
Sure.
there had been two adjournments. It was not the first time that he stated that he did not wish to appear. The case was adjourned on at least two occasions, and he stated that he did not wish to be present. He sent a letter to the judge. He sent a letter to his attorney. So, I mean, to some extent, you're being a little bit disingenuous in terms of exactly, you know, what occurred.
I completely disagree with Your Honor that we're being disingenuous. The facts are fully laid out in our brief, and I'm certain that Your Honor had an opportunity to read those facts. The point here is whether the court exercised sound discretion at the time that it denied the adjournment, and notwithstanding the prior adjournments, Mr. Johnson had a strong interest in getting a chance to do just what he asked the court to do, which is he wanted to come into court after his release from prison.
Yep.
and
We
to
got that,
have
Mr.
to stay
Cooper.
in court. Thank you, Your Honor.
Got it. Thank you. Thank you both.
Thank you.
Cedeno versus Pacelli.
Yes, good afternoon, Your Honor.
Okay. Okay, let me hear from the Pacelli appellants. Who do we hear first? For you, Mr. Kelton, for Atessa?
Yes, Your Honor. I'm Justin Kelton for Appellant Atessa Pacelli. Thank you, and may it please the court. This is a defamation case that was filed in retaliation for an earlier case alleging that Mr. Cedeno sexually assaulted Atessa Pacelli. That case is ongoing right now. In this case, Mr. Cedeno sued Ms. Pacelli and her former husband, Anthony Pacelli, who's represented by co-counsel here, alleging that a number of statements all over the internet about him were made by the Pacellis or any number of John Doe defendants and were defamatory. The Pacellis have sworn under oath repeatedly that they have nothing to do with these statements. And the complaint, although it is very, very long, includes hundreds of allegations, does not include detail about which of the defendants, including the John Doe defendants or either of the Pacellis, allegedly made any of the statements at issue.
Well, he's alleging a scheme where your client was part of hiring folks to make the defamatory statements. Am I correct?
I believe he's alleging that one or the other of the Pacelli defendants may have hired some unknown number of people at some unknown time to make some unknown number of these statements.
Why isn't that sufficient under the posture of this case?
Because, Your Honor,
is discovery completed?
No. We're in the early stages of discovery in the case, but the allegations as pleaded have no particularity. If you were to show this complaint to somebody and say, tell me what Atisa Pacelli did wrong here, you could not answer that
This
question.
is Judge Gonzalez. Aren't there a great many references to different allegedly defamatory statements or in the complaint?
Yes, Judge Gonzalez.
They don't have attribution by way of who made them, but they have other information, right? Like the date and the Earl in particular, where it appeared on the internet. Isn't that enough?
No, Your Honor. In this case, we don't believe it's enough because there's not sufficient particularity to identify the speaker of the state or the maker.
How do you do that?
Fletcher doesn't, just to piggyback on Justice Gonzalez's point, Fletcher versus Dakota doesn't require that he specify exactly which one of the defendants made a particular statements, right?
Well, Fletcher, Your Honor, is kind of a different case here, and we think it's distinguishable in an important way. The addition of this unknowable number of John Doe defendants takes it outside the Fletcher context, where in Fletcher you had words spoken by one or more of the individual defendants. In this case, there could be any number of individuals who are alleged to have been involved in this supposed scheme.
So let me jump in. So don't you need discovery? Since this is a motion to dismiss, don't you need discovery in order to flesh out all this information?
Well, Your Honor, we believe there's a pleading burden to identify the speaker when you make a defamation claim.
Don't you need discovery to identify the speaker given the nature of postings on the internet?
I don't think that the plaintiff should need discovery to sue a defendant that it claims had something to do with this scheme.
But counsel, because we're talking about a scheme, are we talking about more than just a speaker? Are we talking about these individuals who may have had aided and abetted or had other individuals post these reviews on Google and on, Google Review and on Ripoff? Isn't that why we need the discovery to determine whether or not they were the ones who enlisted these individuals to post these reviews and possibly posted these reviews themselves?
No, Your Honor. When you name somebody as a defendant in a lawsuit, you have to have a basis to think already before discovery that they did the wrong thing. You don't sue somebody for something you found on the internet.
But we have those allegations.
We have
those allegations. That's what is alleged in the complaint. The complaint alleges that they had these individuals, John Doe, Jane Doe, post these reviews. They, meaning your clients, had these individuals, Jane and John Doe, post these reviews on Google Review and on Ripoff, which defamed the plaintiff.
But Your Honor, with respect to any specific allegation, and there are hundreds that are just dumped into this complaint indiscriminately, but with respect to any specific allegation, the court can't tell, and we, the defendants, can't tell why they believe we had anything to do with it.
But that's why I think the way that you're trying to distinguish Fletcher on the ground that case involved only 6 individuals who alleged to have made the defamatory statement compared to any number of unknown persons in this case. I don't think that that's a valid. I mean, it's a difference. But I don't think it's is a relevant difference or an important difference. As long as, and I'm reading from Torres versus Prime Realty case, which is a First Department case, 2004, as long as the circumstances of the publication were sufficiently set forth in the pleading. That's why talking about the scheme and talking about the circumstances under which the allegations were made is very relevant, and that's why it's not fatal to the complaint, at least at this posture.
Well, Your Honor, Torres also is an extremely limited universe and also a very limited time period. You had one single meeting where one of 2 individuals are alleged to have gotten up and made a statement at that meeting, and the plaintiff said, well, it was one of those 2 individuals that made the statement at the meeting. Here you have an unknown number of people. You don't even know where or when they're alleged to have made these.
Well, counsel, don't you have?
Wait. Can I mean, you have in the complaint, you have the dates, you have the text, you have the context, you have the URLs. I mean, what else do you need? you don't have to prove the case at this posture.
No, it's not a proof issue. It's a pleading issue. It's a 3211 issue.
I understand this.
To state a cause of action for defamation, you have to say this person did it and here's why they did it.
But you also have the content, and the content has a correlation to the allegations that the defendants make, both of them, against the plaintiff. It's not as if we're talking about something different. You built me a house and my house fell down, and you're the worst contractor in the world. We're talking about allegations concerning a relationship with the wife.
Well,
they form the body of these emails, these 120 plus alleged defamatory statements.
Right. I mean, they specifically also saying that the Pechellis were responsible for authoring the defamation, for publishing it, or causing the others to publish them, the John and Jane Does that was sued. I mean, how much specific do you need?
Well, I'd like to try to address both of those questions. Just with respect to the most recent question first, Judge Acosta, I think those are really conclusory assertions without any factual underpinning as to why the plaintiffs believe that it's the defendants. With respect to your question, Judge Gonzalez, if you really look at the majority of the statements in Schedules 1 and 2, many of them have nothing to do with the sexual assault allegation by the Pechellis. In fact, if you look at Schedule 2, and for example, paragraph 263 in Schedule 2 and 264 in Schedule 2, all they do is allege that a website was posted. They don't say what was on the website, why it was defamatory, anything about the content. And there are more examples in Schedule 2. If you look at paragraphs 269 and 270, they say, again, that a website was posted. They don't say what was in the website. They don't say why it was defamatory, plainly insufficient as a matter of pleading. With respect to Schedule 1, there are reviews like, for example, paragraph 133, the very first review in Schedule 1, that says, I may be forced to file bankruptcy because of his fees. That is not in any way tethered, even remotely, to the allegations in the sexual assault case. So the concept that you could somehow link these alleged defamatory statements to the plaintiffs because there's a correlation between their earlier sexual assault allegation is not accurate. If the court would indulge me, I have a few more points to make that I want to make sure that.
Yeah, I please make them quickly because I'm giving you more time than necessary.
Thank you, Your Honor. Just with respect to trade libel, very quickly, the lower court erred in not addressing or dismissing the trade libel claim. Trade libel is a separate cause of action. It requires special damages in the form of loss.
Can he replead to show special damages?
I don't know if he can. He hasn't done it yet.
I won't spend too much time on that claim.
I don't think he'll be able to, but he certainly has not done it as we sit here today. With respect to publication, a lot of these websites that are listed in Schedules 1 and 2 are obscure websites, obscure URLs with numbers and letters in them that many people on the internet, perhaps most people on the internet, would never see.
But isn't it true that if you do a search and you know how to do it, those websites will come up?
Not necessarily. Not all of them.
You do a Google search, you do a duck, whatever it is, duck.
Yeah, but why aren't we talking about damages? How many people see it? It's only a byproduct of what the damage is. You only need one person to see it, and that could be construed as defamatory, right?
That's true, Your Honor, but he does not actually allege that any one person saw it. If you read the hundreds and hundreds of allegations in this complaint, nowhere does he say a client saw it, my mom saw it, anybody saw it, and it embarrassed me or I lost any business.
Mr. Kelton, once you put it up on the internet, though, even if it's up for a day, it's published, it's available to the public, and it may impact on damages, but in terms of satisfying publication, that does it.
Well, Your Honor, I'm sorry. I was just going to say, I think there's a distinction between making something available and actually having somebody see it. There's lots of content.
I think that's a distinction without a difference. I think for the purposes of this causes of action, I don't think that matters. But let me hear from Ms. Strauss first.
Thank you.
Those 3 minutes were long.
Thank you, Judge. Well, mindful of the time that it's past 4:30 and acknowledging that the arguments raised in appellant Anthony Pacelli's brief are substantially similar to those raised by appellant Atisa Pacelli, I would simply comment with regard to the publication element that, again, plaintiff is responsible for specifically pleading at least one person who is not an agent of the plaintiffs viewed these allegedly defamatory statements. And, you know, while yes, the fact that these statements were available on the internet for some unknown period of time, that does not lead to an inference or presumption.
But that's not what we held in Torres, right? What we held in Torres is that as long as the circumstances of the publication were sufficiently set forth in the pleading, that's enough, at this stage at least.
Yes, Judge, I would submit that there is actually distinction given the nature of the internet, which has over 1 million terabytes of information. Simply because something is available online does not lead to an inference that anybody saw it.
So I think Justice Gish would probably disagree with you because she actually rendered a decision in Penn Warranty versus Giovanni. Wherein I think she may have held the opposite concerning publication on the internet.
Yeah, I kind of see it like a billboard. You know, you put up a billboard, you know, it's there. Even if you can't say, gee, somebody passed this road, you're published.
Well, yes, Your Honor, appellants respectfully disagree, but at this time I will rest on my papers and cede the floor to counsel.
Thank you, Ms. Strauss. Okay, Mr. Solkowitz?
Yes, Your Honor, thank you. I guess there's just a few issues I want to address, and I think the biggest issue was sort of this pleading of particularity and the concept that random defendants were chosen is absolutely rebutted by the evidence that was before the court. If you were to look at the affirmation that was submitted, and it's in Appendix A284 to 290, I personally detailed the extensive amount of work that went into determining who these defendants were and their scheme. What ended up happening is we're in an age where it wasn't picking random people. Review after review were coming online, and we were able, through the 3102 process, determine that someone was buying fake Gmail accounts, and someone was paying individuals online as well in order to write reviews concerning my client. We took it a step further. We were able to get information from the credit card company itself, and all this was submitted to the court in response to the motion to dismiss. And the credit card company actually showed us that a person called in one time in order to check their balance. And that number led right back to the Pacelli's house. Now, it was a house that was a number owned by both Mr. and Mrs. Pacelli, which is why they're both named defendants. The concept that we were then able to sue the Pacellis for actually writing each statement just was rebutted by the evidence at the time, because IP addresses showed that they were created by someone in India. So we have proof that was submitted to the court relating to whether or not the Pacellis themselves were involved in the scheme, and obviously they were. I would also note that this is very consistent, the pleading requirement itself, with Harris v. Structure Tech. This court's decision that was rendered on February 9th, 2021, where it discusses the pleading requirement and what information is contained within the Pacellis, in the defendant's possession at the time the pleadings were done. I will also say that the concept of treating each schedule as a single entity, I think, was not what the court did. What the court ended up doing is they went through each statement, and they actually said that we were unable to properly plead statements of fact with certain statements, and those were excluded from the complaint, and the plaintiffs and the defendant's motions were granted 2 specific statements. So the court actually looked through each and every statement that was pled. If the court has any questions.
No, I think we're good. Thank you.
I was just.
Oh, I'm sorry.
Just the question of damages.
Yes,
which was raised earlier with respect to your adversary. How do you expect to plead damages here and trade libel? Are you?
So I would concede that they are not pled with particularity pursuant to what the statute requires as part of the pleading stage, but it is our contention that this, along with many of the other issues raised by appellants on appeal, were raised for the first time. So trade libel is separate and distinct, obviously, from defamation that occurred against Mr. Cedeno and his firm.
Okay, thank you. Okay, let's get back 1 minute to each. Mr. Kelton.
Thank you, Your Honor. Just one point very briefly. The trial court, although Justice Chan may very well have read all the allegations and analyzed them, did not delineate in her order which allegations are in and which are out for the most part. And in fact, in certain instances, had inconsistencies between which allegations are actionable and which are non-actionable. And we submit that that's a reversible error. Obviously, an allegation can't be both. With respect to damages,
counsel, there was no trial, so I don't know if that it would be a reversible error, but you certainly had the ability to re-argue, didn't you?
They would have had the ability to re-argue. They ended up appealing, but we think it's reversible error to have statements in a judicial decision that are listed as both actionable and non-actionable. With respect to damages, same type of issue. If there's a statement that is defamation per se, that is actionable as defamation per se, then damages are not necessarily needed to be particularized. But for the other statements, and the court didn't delineate all the other statements that are actionable but not per se, damages would need to be alleged, and they were not alleged here.
Okay, thank you, Mr. Kelton.
Thank you, Your Honor.
Yes, Judge. I would just comment that respondent has conceded that they didn't plead the proper special damages required for trade libel, specifically lost dealings. And so I would submit that it's insufficient to simply, hand wave this issue away and say, well, we believe that through discovery, we will be able to establish the requisite type of special damages. This is a pleading requirement, and counsel has not properly pled this cause of action. So we would submit that given that the lower court's decision did not address this cause of action one way or the other, we would submit that this be remedied.
Thank you. Thank you, Ms. Jones. Thank you, everyone.
Thank you, Your Honor.
Thank you.
People versus Dre.
Good afternoon, Your Honors. Mark Baker for Appellant Benjamin Dre.
Good afternoon.
May it please the court. Given the sharp dispute of fact, a hearing should have been ordered on this 440 motion. I speak of, and I think I simply need to commend your attention to two of the documents attached to the reply papers in the 440 motion, in addition to the papers itself. I speak first of the affidavit of Sylvia Wychick, who, in reply to trial counsel's denial of our allegations. Also, the supporting affidavit of Manuel Palomo, who was a co-detainee with the defendant in Rikers Island, and who defendant referred to his own attorney for Mr. Palomo's representation. Sylvia Wychick firmly corroborates defendant's allegations, which are categorically denied by trial counsel, that counsel never told defendant the decision whether to testify was his and his alone to make, as required by.
But your client in his own affidavit stated that regardless of whether his attorney told him that it was his choice to testify or was not his choice to testify, that he was going to testify.
That's correct.
So what is the issue then?
The issue is, the fact is, and the most important aspect of this, because obviously I understand cases that have held that a defendant is responsible for his own perjury. But in those cases, you have the attorney following the rules in People versus De Palma, not commenting on it, telling the judge that defendant is testifying on his own insistence, and don't make discussion about it in the summation. In this case, the defendant said if he knew it was his right to decide whether to testify, he would have known as well that it was his right to testify to what he knew to be the truth. And he would not have testified to the story that was fabricated by his counsel.
And also counsel in his affidavit categorically denies making those statements and making those statements to your client. Also, the defendant made inconsistent statements in terms of statements that he made at ECAB when he was first interviewed by the prosecutor. And also, counsel stated in his affidavit that he prepared the defendant and that he went over the cross-examination of the defendant, the potential cross-examination of the defendant at trial.
You've laid out the very reasons why a hearing should have been ordered as required in People versus George, just decided last year, in which Justices Gitch and Gonzalez sat. The fact of the matter is that we not only have the denial of every one of those points that you've made, Justice Weber, by the defendant, but it's corroborated by Sylvia Wycheck, his girlfriend, who attended every meeting.
Yeah, the only the quote-unquote corroboration is that he allegedly told her something different. But again, assuming that that there was a hearing, she testified to that. The defendant testifies to what he's going to testify to. Counsel testifies to what he's going to testify to. Why do we need a hearing? Everything is on papers, which is exactly what the trial judge ruled. There's
The trial judge said that counsel denied the allegations of the defendant. Sure, of course he denied it, but that's why we have hearings. The fact of the matter is, according to defendant and Ms. Wycheck, when the defendant being confronted with this defense that counsel was fabricating, and by the way, Mr. Palomo's affidavit states that when he went to see counsel.
I have to say I'm listening to you, but the bottom line here is that the defendant lied on the stand.
That's correct.
And he's saying, yeah, I lied on the stand, but he made me do it. Yep. My attorney made me do it. I didn't know what was going on because my attorney didn't tell me what was going on. So I lied on the stand. Is the lying on the stand the crux of this case?
The lying on the stand is an important part of the case. There's no question. But
How
why
does that constitute ineffective assistance of counsel?
Because it was counsel who told him that you don't have. The defendant brought up the question when he was confronted with the story that he was supposed to tell, and it was corroborated by two people that counsel made up the story. He said, "What about my 3 prior statements where I said I can't recollect anything because I was intoxicated?" And at that point, counsel said to him, "Don't worry, this will not come up. It's inadmissible." After he lost the Huntley hearing, and after, in any event, even if he had won the Huntley hearing, it would have been admissible for cross-examination impeachment purposes. So the defendant believed, based upon his advice from counsel, a very weak English-speaking defendant who's a French national who speaks fluent French only.
And so he does not know a lie, the difference between a lie and telling the truth.
He knew
counsel, this goes back to the whole issue as to why a hearing would have been necessary. The hearing would be necessary only if there was additional information which the judge would have needed in order to render the decision. Everything we've just spoken about was submitted on the motion.
A court must conduct a hearing respectfully under George before denying 440 motion, unless an allegation of fact essential to support the motion is contradicted by a court record or is made solely by the defendant and is unsupported by any other evidence, affidavit evidence. This is supported by other affidavits.
Judge Gish, let's see if we can get it the other way. I guess what my colleagues are saying and why we're scratching our heads on this is that if we assume that what your client said was true, even though the attorney disputed it, let's assume it's true. How does that help him? He is responsible for lying on the stand. And so what difference does it make, really?
Because he also has a need, in this case, as completely unfamiliar with the criminal justice system, to listen to when his attorney insists that you will not use an intoxication defense. Forget about what you said. You will have to say that it was consent, not preparing him for what he was then going to be facing. I understand what you're saying, Justice Gish and Justice Weber. He perjured himself. There's no question about it. But put yourself in his shoes. He is told by his lawyer, forget intoxication. It's not going to work. A lawyer who never investigated it, who we had 3 witnesses who would have attested to that, who I've been able to find in my motion, but the lawyer claims were unavailable at the time of trial. And in this case,
the attorney who stated that he viewed the videotape surveillance, he viewed the defendant getting out of the cab, walking across the street, walking into the building. He viewed the defendant's statements with the prosecutor at ECAP. At no time did the defendant appear to be intoxicated. And the defendant himself stated that he was not.
Defendant said,
he,
I'm sorry.
Go
Defendant
ahead.
repeatedly he couldn't recollect anything because he had been intoxicated.
Okay, thank you, Mr. Baker.
I'm sorry?
Thank you. You've gone way over your time.
Good
People?
afternoon. Good afternoon, Your Honors. Can you hear me?
I can hear you.
Okay, great. May it please the court, my name is Ellen Friedman, representing the people. Your Honors, the court correctly denied the 44010 motion without a hearing because it was clear that the defendant was afforded the effective assistance of counsel. A defendant isn't entitled to a hearing when his claims, even if accepted as true, don't make out ineffectiveness, and that's what the case was here. His first claim was that there was a factual dispute about whether his attorney advised him that it was his right to testify. So he was entitled to a hearing. And as you alluded to already, first of all, that claim wasn't credible. It was based on his own self-serving allegation and that of his girlfriend based on what she was told. She admitted she wasn't there for the meetings. And anyway, even accepting it as true, he admitted that he would have testified anyway. As far as the next argument, that there was a factual dispute about whether the attorney directed him to testify to a concocted defense, whether the attorney knew that the encounter wasn't consensual, but instructed him that he had to testify that it was. Again, not credible. The girlfriend, again, was an interested party who was saying what he might have told her, but the affidavit of his fellow Rikers inmate also just doesn't support the claim at all. It said nothing other than that the attorney talked to him about the defendant's case and said at one point that the defendant wanted to pursue an intoxication defense. Well, he encouraged him to pursue a consent defense. Obviously wasn't at the meetings. It didn't go into the real heart of the claim. And again, putting credibility aside, even if it was, even accepted as true, that attorney did direct him to lie. The law is crystal clear that a defendant's responsible for that decision, and it doesn't constitute ineffective assistance. So obviously, defendant has to admit that, and he says that in this case it was different, given the context, given the situation, because his attorney didn't warn him that he could be impeached with his prior inconsistent statements. But even if that were true, and the record suggests that it's not, but even if it were true, that doesn't show any additional prejudice. If you look at the trial transcript, he said the same thing on the first day when he claims he wasn't prepared that he did on the second day, which is he made the statements because he was tired, he didn't have an interpreter, he didn't understand his rights, and he was just following instructions of what his attorney told him to say at the time. And he said that again, and he said, oh, and then eventually that's what my attorney told me to say. So he said it both days, before and after.
Okay. Thank you.
If there are no further questions, I'm happy to rest on my briefs.
Thank you, Ms. Friedman.
Thank you.
4 points.
Can you get 1 minute?
Yes. The attorney told him under no circumstances will you be impeached. The attorney had no strategy with respect to this because, as indicated in the Zaborski case, page 56 of our brief, to have a strategy which is completely belied by the record is not a strategy at all. In that case, there was an entrapment defense, which opened up a whole sort of new issues, and the court said that flew in the face of what the defendant had prior said. Remember and keep in mind, Your Honors, that I gave the draft of this motion to counsel before I filed it, asking him to and inviting him to tell me if he found anything in there that was wrong. He ignored me. I gave him the opportunity because I wanted this to be an accurate motion. Lastly, on the appeal from the judgment itself, the fact of the matter is that he fought against an intoxication defense, and the court jury itself found that it wanted to hear the charge on intoxication. So the judge only gave it as to
the burglary. Only as to the burglary, not as to the sexual abuse.
That's precisely my point, Justice Weber. The fact of the matter is that the intent under sexual contact definition that this court held in People versus in matter of Cliff is decided in our brief, is a specific intent. And if the council had asked for the charge on that second count as well, it's very likely that the jury could have acquitted on that ground likewise.
Thank you, Mr. Baker. Thank you both.
Thank you, Your Honor.
Thank you, Your Honor.
Garcia versus Rosario.
Good afternoon, Your Honors. May it please the court, Howard Cohen for the plaintiff. This case hinges on two issues which I believe transcend the individual case. First and foremost is polling the jury. As the court's aware, the verdict was reported. Plaintiff's counsel made a specific request that the jury be polled on all the questions. The court denied the request and only polled the jury on one of the 9 questions. We've cited the cases from the Court of Appeals, Duffy versus Vogel. That's an absolute right.
So we agree that polling the jury is fundamental, right? It's a fundamental
Correct.
right. It's not ministerial. We
Correct.
agree that it wasn't done in this case, right?
Correct, Your Honor.
And the purpose of it is to give the jury or the jurors an opportunity to change their mind one last time. That's why most judges will go ahead and do the polling regardless of whether they are asked or not. Correct?
I couldn't have said it better myself.
And it's not subject to a harmless error analysis.
Correct, Your Honor.
Did I miss anything?
Yeah, nothing. And of course, there's the second point, and I just would comment on that. I obviously wasn't there, and everything I'm reading about the juror who was discharged sort of third or fourth hand. And for all I know, if everything was true, the juror may have been eminently dischargeable, but proper procedure wasn't followed because the judge didn't talk to the jurors or to that juror.
So we don't really know what happened.
We don't know what
nobody
happened.
asked the jurors.
So there should be a hard and fast rule, at least speak to the person before discharging him. It's another ground that reversal is mandated. Thank you, Your Honor.
Thank you, Mr. Cohen. Let me hear from the other side.
Good afternoon, Your Honors. My name is Patrice Coleman. I'm from Pillinger Miller Torello. I represent the respondent, Rosario, in this case. Your Honors, it's our position that the only issue before this court, as determined by plaintiff appellant's notice of appeal, is the adequacy of the jury's dollar verdict of the amount of the award. That is what is stated in the notice of appeal.
Well, he asked that the jury be polled. It wasn't polled.
Well,
Isn't that a fundamental right that doesn't need to be preserved? I thought we went over that. Does it need to be preserved?
I believe it needs to be preserved, Your Honor. I don't think he's appealed that issue. I don't think it's in his notice of appeal.
Yeah, but the notice of appeal, Ms. Coleman, it doesn't say this appeal is limited to damages only, does it? Said I'm appealing from the judgment.
Well, I think, Your Honors, if you look at it, it doesn't say each and every, it doesn't have the broad language you normally find. It says which
Yeah, but you want us to read it limitedly. And so the question really is, in order to have a limited notice of appeal, doesn't it have to have the limitation in the notice of appeal? Otherwise, it's just a general notice of appeal.
Well, I think a general notice of appeal would normally state language such as
fancier ones may.
This one states which
better written ones may. But again, I'm asking you, where is the authority for the proposition that unless you specifically state each and every part of the judgment, that a plain old notice of appeal, which has no limitation in it, is limited?
Well, Your Honor, I would respectfully suggest that this notice of appeal by its own terms is limited.
Read me the limiting language.
Which awarded plaintiff only $500,000 for past pain and suffering, zero for future pain and suffering,
Isn't that just
zero for future.
It's just a characterization of the judgment.
Ms. Coleman, let Ms. Gish ask the questions, please. Talking over her is not going to be successful.
I'm sorry.
I was going to say, that is not limiting language. That is descriptive language of the judgment which is being appealed.
Does it not say
that's how I
notice
read
of
it.
appeal from the judgment and then continue on to what the judgment was? Isn't that what it says?
Well,
No,
I'm sorry.
does it say notice of appeal from the judgment and then state what the judgment was?
Well, it only states that one portion, and
But does it say notice of appeal from the judgment?
yes, it does, Your Honor.
Okay, so isn't that a notice of appeal from the judgment?
Do you have any other points, Ms. Coleman?
Yes, Your Honor. I would just respectfully as to the points as to the adequacy of the jury's verdict, which is part of the appellate papers. As we stated in our brief, there's a ton of testimony, credible evidence that the jury could have found and did find that this plaintiff didn't have a permanent injury, wasn't entitled to any future damages and award.
Okay.
As to the other issues, my co-defendant, co-respondent, I believe is going to address those, and we would rest on our papers unless the panel has another question for me.
No, I think we're good. Thank you, Ms. Coleman.
Thank you, Your Honors.
Good afternoon, Your Honors. And as we hit the 5 o'clock mark, I'll try to be brief. Your Honors, I will dispute two of the things that were said earlier. Let's start with the polling of the jury. And I agree that obviously polling of the jury is an absolute right unless it's waived. In this case, we dispute that the polling wasn't done. There was polling done by the jury. And we believe that any further polling was waived. We got to remember context.
How was it polling as to one question?
I'm sorry?
How was it waived?
How was it waived? I'm getting to that, Your Honor.
Having the 5 o'clock hour you just alluded to. So please, yeah, go ahead.
Yes, I'm moving there, Judge, moving there. The judge, after the jury, the foreperson started reading the verdict sheet, there became an issue with question number 9. She misstated reading whether there were 6 or 5. Then the judge said, all right, let's have an off-the-record discussion. We had a discussion with the judge, counsel, and we got together and she said, all right, what are we going to do about the issue about the misreading?
Is this part in any part of the court record? Or is this the off-the-record discussion?
It's in court record page.
Counsel, doesn't the plaintiff say at page 1017,
yes.
Judge, so what was said, I'd like the jury polled on all the questions, and the court responds, okay, your request to poll all the questions is denied. And then it goes on to,
correct.
The judge says, I am going to permit question 9, so there is no confusion. How is that a waiver?
Because the procedure, given the context here, Judge, her decision to only poll on question 9 related to the issue of what just happened in court. So she's to correct any confusion that might have been had when the foreperson misread the.
But that's not what plaintiff asked. Plaintiff asked to poll on all the questions. In fact, most of the time, because we know that it is a fundamental right. And by the way, Court of Appeals in Holstein, Rueda, those are all cases talking about the need, that there's no need for preservation of that fundamental right. So
understood, Your Honor. Well, however, can I just interject there that the plaintiff's counsel did not object after the lower court judge said, yes, all right, only on question 9. We're going to only do question 9. Is that okay? She said, okay. And there was no objection placed on the record by counsel. There was no further discussion. What counsel could have said was said, Your Honors, I understand that you're giving, and I thank you for giving me clarification.
I read the record differently. I read the records as when they return to the courtroom, the plaintiff counsel stated on the record that he wanted the jury poll on the entirety of the verdict. That's how I read the record, not simply question 9.
Additionally, the okay was not from counsel. The okay was from the court.
Correct.
It said, okay, so please listen carefully. It's not that there was a waiver because plaintiff's counsel said, okay.
I understood. That's what the judge said. Oh, okay, everybody. That to me says, hey, plaintiff's counsel, if you have any further objection to what we're going to do here as far as polling, please, you're free to say it.
How many times do you have to say, I want the jury poll on its entirety? I mean, if the judge denies it, it's preserved. You don't have to keep asking the judge and harassing the judge about it. In fact, the judge will probably get annoyed, right?
I understand, Judge. We didn't have a shy plaintiff's counsel in this case. I know, I was there. But
we can't make our rulings based upon how shy or not shy counsel is.
Yeah, we kind of have to look at the record, and the record indicates that plaintiff's counsel asked to have the jury polled.
It did say that, and the record is what it is, and I'm not disputing that. I'm just saying, taking under the context of the whole situation of how this arose, plaintiff's counsel could certainly have said, all right, I understand that you're polling on question 9, but I need you to poll on all of the questions. She did her method of polling, and I say that is polling. It's limited, obviously, but here for the plaintiff's counsel's failure to object to that, to take an exception to what she did after she did it, that precludes.
Okay, if I ask you for the $100 that I'm entitled to, and you only give me 10, do I have to keep asking for the rest? No, I ask you for what you owe me.
I would pay you right away, Judge. Yes, I understand. I understand.
Thank you, counsel.
I'll rest on the brief regarding the other issues, Judge.
Thank you so much, counsel. Mr. Cohen, we good?
I'll be very brief. Just two
brief.
things. Very brief. CPLR 4017 says once the court made its ruling, you don't have to accept further. That's CPLR 4017. Second thing, I would refer the court to page 6 of the appendix, which is the informational statement filed with the notice of appeal and sets forth the grounds for appeal, which include the court erred in failing to properly poll the jury pursuant to the request of plaintiff's counsel, and the court erred in discharging a juror and replacing it with an alternate without proper inquiry. So that was stated.
Got it. Thank you so much. Thank you all.
Thank you, Your Honor.
Okay. Simmons versus Berg.
Good afternoon, or good evening, Your Honors. My name is Matthew Cuomo for the appellants Rebecca and Catherine Berg. May it please the court. The lower court invaded the province of the jury when it decided, based upon one fact, while ignoring other facts, that Rebecca Berg negligently operated her vehicle and that negligence was a proximate cause of the accident. There are so many disputed facts in terms of what happened here, and there are so many things that a jury could look at in determining whether Ms. Berg operated the vehicle in a negligent fashion. And it seems to me that
I thought that she admitted negligence by basically not seeing what was there to be seen. I mean,
no, Your Honor.
She testified that she didn't see plaintiff before the accident,
and
that the sun was in her eyes.
Well, no, she didn't testify that the sun was in her eyes. On that piece, the Supreme Court just basically misread the testimony. What's significant, Your Honor, is that a jury could determine a non-negligent reason for not seeing the plaintiff. Remember, the plaintiff testified at her deposition that she had come out of the deli, talked with some people for about 10 or 15 seconds.
Counsel, I know what you're saying as far as what the video shows and what her testimony said, but don't we still end up at the same place that Judge Acosta referenced, which is the driver admitted that she made a left turn while the sun glare impaired her vision, and she didn't see the pedestrian, and that's one, and two, the pedestrian is close to the double yellow line, so it's not even at the curb. The pedestrian is into the street already, but she doesn't see the person, and she admits that.
Well, Your Honor, this gets back to the fact that a jury should be able to hear that explanation. And that explanation is that the plaintiff was not honest about how long she was standing at the curb. It's entirely possible. As you make that left turn, you're not looking just where the plaintiff comes from. You have to look across the other side of the road to see if pedestrians are coming the other way. You have to be looking for vehicles coming up the road in the opposing direction.
What about the video? What about the video surveillance camera? And also, I always thought that the pedestrian had the right of way.
Well, no, here, Your Honor.
I mean, and you're talking about, you know, she was not, the plaintiff was not honest, or in terms of, you know, how long she was at the curb. The video surveillance shows her, you know, stepping out into the crosswalk. And as Justice Gonzalez just stated, you know, it's at the double yellow line, right? So she's out in the middle of the street.
Your Honor, you're mistaken in that she's in the crosswalk. Number one, the plaintiff admits she's out of the crosswalk. She marks that she's out of the crosswalk. So under
the video shows her a step out of the crosswalk, walking towards it. But even so, that's just her comparative negligence. That under Rodriguez, that will go on to figure it out.
Well, I understand that point, Your Honor, but here's the other piece. The plaintiff acknowledges that she walks into the side of a slow-moving car. She sees the car. She walks into the side of it. She could have stopped. That is something that a jury could consider.
Is that what she said?
Where is the no negligence on your client's part? That's good. You can argue that for comparative negligence, but where is the no negligence issue of fact for your client?
Your Honor, there are two questions that a jury would be presented with regarding my client: whether my client operated the vehicle in a negligent fashion, and the second question would be whether that negligence.
You don't think hitting somebody in the middle of a street is negligent? I'm really not getting it right.
It may be negligent, Your Honor, but it's not necessarily a proximate cause of the negligence. The plaintiff acknowledges she sees the car coming. She continues to walk at it. She doesn't get hit by the car. She walks into the side of the car.
There's actually no evidence of that. There's no admissible evidence of that.
Her testimony is the admissible evidence of that.
Counsel, this is Judge Gonzalez. Hello. Doesn't the plaintiff, isn't her testimony undisputed to the extent that she says that she looked in both directions, this is the pedestrian, and she signaled to the driver to alert her to her presence?
That's her testimony, but her testimony is also, Your Honor, I'm looking for it here.
But it's undisputed testimony.
Her testimony is that she walked into the side of the vehicle. The right foot, her right foot was struck by the right front wheel of the vehicle. The right front wheel of the vehicle is at the side of the vehicle. She is not in front of the vehicle. She does not get struck by the vehicle. She walks into a moving vehicle. That is undisputed.
Okay,
That's
thank
on
you,
page
Mr.
172 and 173 of the record, Your Honor. There's absolutely no dispute that she walks into the side of a moving vehicle.
Thank you,
And
Mr.
that alone would be enough for a jury to
Thank you, Mr. Cuomo.
Okay, Your Honor.
Ms. Mercado.
May it please the court. Good evening, Your Honors. Christina Mercado for the plaintiff respondent. Just to respond to Mr. Cuomo's arguments, it absolutely is not undisputed that the plaintiff walked into the side of the vehicle. That's not what happened. The plaintiff testifies that the vehicle hit her. The defendant testifies that she didn't see it because she didn't see the plaintiff at any point in time. And the defendant actually later says, there's a mark on the hood of my car from where it hit the plaintiff. In any event, that argument doesn't even have any merit, because if you were to run a stop sign and get T-boned by another car, just because you're not the car that did the hitting doesn't mean you're not the car that's at fault. But again, to the main point of the argument, because this is under Rodriguez, we were denied our request for a finding of no comparative. So all that this court found correctly is that the defendant driver was negligent in hitting a pedestrian in the middle of the street. The only thing that the video shows, it does not show plaintiff leaving the deli. It shows plaintiff on when she's 3 steps, I think, from the sidewalk. It shows her walk into the street just outside of the crosswalk within inches. And the entire video is, I believe, 10 or 12 seconds long. And the appellants even say that it's 7 seconds from when the plaintiff steps into the roadway, she crosses over the parking lane, she crosses over the next lane, and she crosses almost all the way over the next lane before the defendant hits her. And just to respond to the point that, well, the defendant had other places to look, this defendant had actually less places to look than most drivers who are making a left turn. This defendant's on a one-way road, so there is no opposing traffic. It's the defendant going, the plaintiff walking, she's not seeing her, not seeing her, not seeing her, and then suddenly turns into the plaintiff. The plaintiff had no opportunity to move out of the way of the car. The plaintiff sees the car coming as she's walking, so whether she looked before she stepped off the curb is actually irrelevant because she did look, she saw the vehicle, she saw the defendant vehicle, sees it going straight, and then when it starts suddenly turning, there's no indication that she actually even signaled that she was going to turn, she strikes the plaintiff. And there is no evidence for a jury to find that the defendant here wasn't negligent.
I would rest on that, Ms. Mercado.
So I will rest on my brief if the court has no other questions.
Thank you.
Thank you.
Mr. Cuomo, you got 1 minute.
Just briefly, the idea that we're having this dispute about whether the car hit the plaintiff or whether the plaintiff walked into the car is exactly why it needs to go to a jury. Putting aside the issue of negligence, this could be just an issue of proximate cause. A jury could determine that there was negligence, but it was not a proximate cause. The plaintiff testified that her right foot hit the right front wheel. That's the plaintiff's undisputed testimony. The only way that happens is if the plaintiff is coming from the side into a moving vehicle. She cannot get hit that way if the vehicle is hitting her. The jury should be able to determine at least that issue of proximate cause.
Thank you both.
Thank you, Your Honor.
Mutant versus LVMH Moet.
Good afternoon, Your Honor. Michael Fernandez of Winston and Strawn. With me is my colleague, Aviva Grummet-Morris of the Bar of the State of Illinois. She's been granted permission to proceed pro hoc vice before this court, and we have submitted the requisite notice of appearance. I would ask that she be granted permission to argue this appeal, Your Honor.
It is granted, Mr. Fernandez.
Thank you, Your
Go
Honor.
ahead, counsel.
Good evening, Your Honors. Aviva Grummet-Morris, appearing pro hoc vice for appellant. May it please the court. This case presents a straightforward legal question. Should the arbitration agreement signed by plaintiff with her employer, LVMH, be enforced now that she is raising claims against LVMH? The motion court said no, but it made 3 substantial errors in reaching that decision. First, it refused to enforce the the delegation clause, which says that an arbitrator, not the court, should decide any disputes as to the validity, enforceability, or applicability of the agreement. The United States Supreme Court and the New York Court of Appeals have repeatedly held that delegation clauses in arbitration agreements must be enforced, and the motion court's refusal to enforce the delegation clause is dispositive here, meaning that this appeal can begin and end with the delegation clause. Second, the motion court erred when it found that CPLR 7515 applies to this case. It does not. This court just recently held that CPLR 7515 is not retroactive, which means it does not affect.
We held that in Altman, right?
In Altman, yes, sir.
So we already decided the issue.
Correct.
Because I was a little confused. I read it in the other side's briefs that they didn't think that this court had decided that issue. It may be that our decision came after the cases were briefed.
It did not, Your Honor. It came out before plaintiff filed her response brief. I believe her argument, although I should let counsel make it, was that it wasn't the retroactivity point was not adequately discussed by this court in comparison to what the motion court did. We believe that's not how stare decisis works. That's not how the obligation to follow binding precedent works. So we believe that that issue has been decided. Even if for some reason you were going to set aside the issue of retroactivity, however, there is still the issue of preemption by the Federal Arbitration Act, the FAA. Numerous courts have found that CPLR 7515 is preempted by the FAA, And the United States Supreme Court has repeatedly found that any state statute that tries to carve out a particular type of claim from arbitration agreements, that those state statutes are also preempted. Third, the motion court erred when it found that LVMH nullified a portion of the plaintiff's arbitration agreement when it made a change to its employment handbook policy. That issue should have been gone to the arbitrator pursuant to the delegation clause. Even setting aside the delegation clause issue, however, there is no authority for the proposition that an employer making a change to an employee handbook somehow amends a separate agreement, an agreement that is separate from that handbook, especially where the policy revision says that it is limited to superseding and replacing other policies, and the agreement itself says how it can be amended. So on the basis of those errors, Your Honors, we are asking that that this court vacate the decision of the motion court and grant LVMH's motion.
Counsel, if you could just address the 2018 revised policy a little further.
Sure.
It does say that that employees are free to pursue claims in federal or state court. So why isn't that an upgrading of the initial no arbitration posture of the employer?
A few reasons, Your Honor. First of all, that change to the policy, at most, if you credit plaintiff's argument, changes the scope of the arbitration agreement, and therefore the issue becomes, does the arbitration agreement apply to the claims that she's making? That is squarely within the delegation clause, and so this court can decide this issue simply by enforcing that delegation clause and letting the arbitrator make the ultimate substantive decision. But
does it matter that it was not signed as required by the agreement?
Thank you, Judge Acosta. That was going to be my second point. So the arbitration agreement says how it can be changed. You need an instrument signed by the company. This is neither. The policy is not signed. It's not an instrument. An instrument, according to Black's Law Dictionary, is a more formal legal document that defines rights, duties, entitlements, or liabilities, such as a statute, a contract, a will, a promissory note, or a share certificate.
So here's a different question, counsel. If the employer issues the policy change, the statement, does it need to be signed?
I would say it does, because we have an agreement here that says specifically how it can be changed. There's a reason that parties that are negotiating an agreement put into a contract specifically how the agreement can be changed, so that there's no confusion, so that there's nothing like what's happening here, which is taking a statement that wasn't directed to this particular agreement and saying that it somehow invalidates some portion of that agreement. So it does have to be somewhat formal. It has to be an instrument, and it has to be signed by the company. The company has to be acknowledging that it's giving up a right that it has to enforce that agreement. That's not what this policy did. This policy was a general policy. It certainly applies to employees who may not have an arbitration agreement. It just, in this particular instance, our plaintiff has an arbitration agreement. The general statement can't trump the more specific arbitration agreement statement, particularly where you have two very sophisticated parties. This is a very experienced, very sophisticated litigation attorney. She knew what she was signing, that agreement is separate from the handbook. This is not a case where you've got an arbitration policy in a handbook that's somehow superseded by a later version of the handbook. This agreement was separate. It was years before this handbook came out. And we would suggest that you have to follow the terms of the agreement in terms of how that can be amended. In any event, again, I will rest with the one comment that we believe that this issue should go to the arbitrator pursuant to the delegation clause. Thank you, Your Honors.
Okay, let me hear from the other side.
Yes, Your Honor, this is Stephen Bergstein. My video is not working, but I assume you can hear me. And you can hear me? Okay, I'm sorry.
We can hear you clearly, Mr. Bergstein.
Okay, I'm sorry about the video. I don't know what happened. I have two primary arguments today. Number one, as has already been discussed, management repudiated the mandatory arbitration provision when it revised its policy handbook in 2018. And number two,
what about the issue of the signature?
I don't think you needed a management signature on that. The policy.
But don't we interpret contracts or arbitration agreements or anything else based on the plain language of the agreements themselves? And that agreement says it has to be signed by management, right, or someone with the authority.
But management issues the revised policy. It's management's policy. It's the equivalent of them signing it. If they're issuing a new policy and the policy agreement bears all the imprimatur of company of management policy, what's the difference? They decided in 20.
The policy, the revised policy itself says that it was meant or purported to replace and supersede all written company policies related to discrimination and harassment. But it doesn't say anything about superseding the arbitration agreement. I mean, if that's what you wanted, that's what would have happened, right?
Well, but it's still a change in policy. The company is telling all employees, that's in the language, this affects everyone, whether you have an arbitration agreement or not. If you're harassed, you can go to court. So any rational person reading this knows, okay, I'm not bound by an arbitration agreement anymore. There's no limiting language that says this doesn't apply to pre-existing arbitration agreements. It applies to everyone, including Ms. Newton. And this argument allows this court to permit the plaintiff to go to Supreme Court on her sex harassment case in a way that both honors state policy in limiting arbitration.
Well, that would have been my next question, Mr. Bergstein. I understand, and in fact, I have written a little bit about the dominant state policy in addressing sex harassment in New York. But CPLR 7515 doesn't apply to contracts that were executed prior to 2018, right?
Correct. But this state legislature still maintains a strong policy against arbitration in these cases. That's what the legislature wants. So even if this court finds that the Federal Arbitration Act swallows 7515, this court—
No, but it's not about swallowing. The legislature was created in 2018, and it doesn't, and it only addresses agreements, subsequent agreements. That is, after arbitration agreements executed subsequent to the effectiveness of CPLR 7515. You can't just go back and apply it to any agreement prior to that, right?
That's what this court has held. But what I'm suggesting is that this court can rule in plaintiff's favor without addressing FAA preemption through the repudiation argument that we're making, and therefore honor not only the state's desire to limit arbitration in these cases in general.
I agree. We don't have to reach the issue, the FAA issue, whether this is interstate or not, whether the FAA applies. My question is really on the retroactivity of the statute itself. If the legislature wanted the statute to apply to agreements that were executed prior to 2018, it could have said that, right?
We argued that it did say that, but this court has not accepted that argument in prior cases.
Yeah, I mean, we stuck with Altman, and I don't know whether Altman is going to the Court of Appeals. I know that that's a decision that we just issued last year, right?
It came down late in the process in this case. But what I'm suggesting is that the state still has articulated a policy or a desire to limit arbitration.
A valid and strong dominant policy, no question about it.
And we know what the First Department thinks about the value of the state human rights law, and Your Honor has written those opinions. I know those cases, and ruling in plaintiff's favor, consistent with the 2018 policy amendment, where all employees now can go to court. We're honoring state policy on this. The other argument I want to make
Before you get to your second argument, just one quick question, because you're relying on the 2018 handbook. And now my question to you is to just briefly address your adversary's argument that the gateway issue about what that handbook means is for the arbitrator.
I don't think so. The issue of whether the policy revision alters the arbitration agreement is really a matter of state law for the court. And our amicus brief submitted by Public Justice really covers this issue, citing a case out of the Third Circuit with similar facts, Giuluti versus Citigroup. The issue of whether handbook amendments supersede prior arbitration clause is an issue of contract formation under state law. And Giuluti from Third Circuit cites a case out of the Second Circuit, Applied Electronics versus Newark Markets 645 F3rd 522, that also talks about even if you have complementary provisions in employee handbooks, you're still dealing with the issue of contract formation, which is an issue for the court and not an issue for the arbitrator. So I would ask this court to consider that argument in allowing this case to go to court. The other point I want to make is that we cite in our brief a series of cases from around the country, and I don't know if this has been endorsed by an appellate court in New York, but Justice Knock referenced this, that there are certain actions or things that take place in the workplace that are not really contemplated by an arbitration agreement, and that includes sexual assault, which is what happened here. And you know, when Newton signed her arbitration agreement, you know, maybe she anticipated that a demotion or something might be submitted to arbitration, but I don't think you can expect an employee to reasonably find that being sexually assaulted or sexually harassed would be subject to arbitration. And you know, the cases we cite out of Michigan, New Jersey, Kentucky, Ohio.
We read those, Mr. Bernstein.
And I think this court should seriously consider adopting that reasoning, because those are not quintessential incidents of somebody's employment, sex harassment and assault. That argument also allows this court to allow the plaintiff to go to court, consistent with the state legislature's desire to limit arbitration in these cases. We know why the state legislature passed 7515. We know about the criticisms of arbitration.
Thank you, Mr. Bernstein. Appreciate it.
Thank you.
Let me hear Ms. Gromet Morris, 1 minute.
Thank you, Your Honor. Very briefly, what counsel is arguing for essentially is a policy exception to arbitration agreements, a policy that is from the state of New York. And I believe that this has been already addressed by the New York Court of Appeals in the Fletcher case that we cite, where the New York Court of Appeals clearly says that whatever our state's policies may be, I'm paraphrasing for the sake of time, whatever our policies may be, they must give way to the federal law and the federal policy. And that is addressing specifically this issue regarding a state law-based discrimination and harassment claim. And the argument
that's related to preemption, but public policy can, without reference to preemption, trump arbitration clauses. We've held that legions of times.
But state policy can't trump the FAA. And
that's the preemption argument. Right. Yeah, that's a different.
Thank you, counsel.
Thank you, Your Honor.
Thank you both. Okay. Next case is People versus Warden. Ingrid Torchy versus Warden. And then after that, we'll hear the last case, Primus Pacific. Go ahead, counsel.
Thank you, Your Honors. Good evening. My name is David Turchy. The writ of habeas corpus below should have been granted and Mr. Zimor released on his own recognizance. The writ court erred when it applied first a deferential standard in assessing the denial of a 3030 release motion previously submitted to the same court. This is because no appellate court has ever held that writ court should apply a deferential standard in reviewing the denial of speedy trial release motions. And indeed, when you look at the appellate decisions on it, they tend to delve into the substance of those speedy trial legal arguments. So, and I would submit the people's cases in support actually seem to buttress that, our argument, to the extent that it seems very clear when the appellate courts intend for there to be a deferential standard of review. It's all over the place in the decision. None of the appellate decisions with respect to 3030 review deal with that. The sole case that does apply the deferential standard, the lower court case of Bullock, actually did a de novo 3030 analysis as an alternate basis of reasoning. In that case,
in Bullock, I mean, what they did is the court deferred to the record, and the Nisi Pires, forgive me if I'm mispronouncing it, it's a long day, you know, Judge Biden's decision, because she had the trial, or she had the matter on before her in its trial stance, and so, you know, she was the one most familiar with, yeah, you consented to that one. No, you didn't consent to this one. I'm charging it this way. I'm charging it that way. And even in Bullock, which seemed to make a lot of sense to me, they said, we're going to defer to that court and their assessment on how to count the days.
Your Honor, that goes to an argument I raised in my papers, of course. If the initial court had made a factual determination that I was contesting, that in fact would be, I think, more appropriate. But that is not what is the case here. There is no dispute as to the underlying facts, the records made. The dispute is the import of the law and the binding legal precedent on those uncontested facts. Okay?
You're not contesting that certain of those adjournments that the court found were on consent were not consent.
It would depend on the particular adjournment. There are three in particular, two in especially in particular.
Right, where the court said it's consent. I said they were consented to, and you said no, they weren't.
These the appellate courts have been very assertive in saying, no, that's not consent, and it was error for you to call that consent. And those cases are raised in the brief. This case is easy, I would respectfully submit, Your Honor, in terms of the dates we are talking about. There is just no question. Getting ahead of myself, it's simply put, an affidavit saying, oh yeah, earlier that day I told my adversary I wouldn't be ready. That doesn't excuse the people from being ready in the first instance. It just doesn't. Consent repeatedly by the higher courts, including this court, must be clearly expressed. And that just didn't happen here. It simply didn't. In the interest of speeding along, I'll hit my last 2 points. I do have to amend the record in one way. Beginning of this week, I finally got a COC, Certificate of Compliance. Okay. Admittedly, there was a disaster declared March of last year. The requirement for that went into effect January 1st, over 2 months before then. Certainly, I've made arguments with respect to, I think, a December 19 into January date being chargeable. There are a number of dates that certainly at the beginning of the year appear to have been consented to, and I've not raised specifically, but I do raise what happened October 19, when 3030 went back into effect, both under the executive order and OCA. And in particular, jury trials were begun again in Manhattan, where the case is pending. And so while I would submit, as I do in the papers, the entire period since October 19th, it's been running, especially in the absence of a certificate of compliance, I think at the very least, the period between October 19 through November, I believe it was 16 of last year, when jury trials were suspended again, must be assessed against the district attorney with respect to this matter, and should have been. I think, while there's a lot more I could say, it's in my papers, I will end with this. This is not a writ of habeas corpus on a 3030 release motion, is not a renew and re-argue. It just isn't. A writ is a challenge brought by an individual to challenge illegal and unlawful detention by the government. The fact that the government technically calls itself people doesn't mean that they are somehow immunized from the responsibilities of government. I don't think anyone is saying that, but still, it's worth mentioning. It's one of the foundations of our system of government. We know this, it's in the state federal constitutions, and the Court of Appeals has made it clear in Schildhouse, rigid and strict adherence to procedural protocols have no place in a writ. The underlying court should have considered all arguments going to illegal detention, and it should not have used a deferential standard. Thank you.
Thank you, Mr. Turchi. Mr. Day?
Good evening, Your Honors. Christopher Day for the Manhattan District Attorney's Office, and may it please the court. Your Honors, the trial court judge, Justice Bybin, providently exercised her discretion when she found only 14 days of elapsed time chargeable to the people. The habeas court properly denied.
So now, I mean, let's get to the heart of one of your adversary's arguments. He's saying that 30-30, it's not a matter of discretion, the counting of the days. It's a matter of law, how they're chargeable. What say you?
Judge, I think the fact that there is no authority that supports Mr. Turchi's position and there is authority that supports the people's position, as the court mentioned previously in People v. Bullock, buttresses our argument here. And also on a policy argument, the idea here that we'd have a de novo review.
Well, Bullock didn't talk about indiscretion. She just said support in the record.
Correct.
That's different.
And I think, as Your Honor mentioned previously during the argument here, the reason we have that, and I think the reasoning behind Bullock, is that a trial court is in the best position to evaluate ultimately the reasons for the adjournments. Justice Bybin had
Whether
this
there's
case.
been clearly expressed consent?
Correct, Judge. On multiple dates here, August 22nd to September 12th, September 12th, October 1st, and December 3rd, particularly the December 3rd adjournment, which was in front of Justice Bybin and prior counsel, Mr. Zaltzberg, and I am actually the prosecutor on that case. And I know Mr. Turchi had mentioned that Mr. Zaltzberg had said on that day. And in fact, I had conversation with him days before about our case. I made the record I did based on that representation. And in fact, if you look at the record, part of what I say is that as Mr. Zaltzberg had said in court that he was answering right on a previous case, that had happened in front of Judge Bybin earlier that day in a calendar call. This is not part of the record now in front of the court, but these are all reasons why the trial court is the best to evaluate ultimately these adjournments for the reasons as Bullock states and also is in the people's papers. It's not the position.
Is the appeals court bound by the determinations made by the trial court in terms of the calculation?
I think in this kind of case, Judge, the appeals court is reviewing ultimately the habeas court's decision on Justice Bybin's ruling. And in that, I think the standard review should be abuse of discretion as similar to a bail review. So I think in that sense,
as opposed to whether the calculation was correct or not, right?
Correct, Judge. Yes, I would agree with that.
So it's just an abuse. It would be an abuse of discretion on the part of the trial judge.
Correct.
And not as to the calculation itself.
That's correct, Judge. And I do, as the judge previously mentioned, when Mr. Turchi said there was no factual dispute, I think, in fact, there is. That is what he's arguing, that if you read these minutes and you look at these different things, he is saying the consent is not expressly given, where in fact, that's the people's position. This is a dispute that was raised, litigated, and the Judge Bybin decided that, in fact, consent was given. Justice Conrad reviewed that.
And it was based on her, in part, on her personal familiarity with the case and what sort of transpires in trial parts day to day, and dealing with attorneys.
Yes, Judge. And moreover, in addition to part of the other arguments here that people have made in response, Mr. Turchi had referenced arguments that were made outside of the trial court. So there was two arguments brought up in the habeas writ that are not properly now in the people's position in front of this court. Arguments that were never made to the trial court, specifically adjournments from January 1st to March 20th. Specifically, Mr. Turchi's argument is that CPL provision 3030 sub 4, the exclusions, somehow don't apply absent a COC. That argument was never made before the trial court, and the people did not respond to that because it wasn't before us. So to make that argument now in front of the habeas court is improper. Moreover, the argument about October 19th clearly could not have been in front of the trial court.
It keeps rolling in terms of the days, right? I mean, he may be right, though, but that's a different issue.
Correct. And I think because the fact, as Mr. Turchi brought up this factual dispute about whether the people were ready to go in October, there's an email and there's The record's woefully inadequate because this wasn't before a trial court to evaluate that. And to have a habeas court then to conduct a factual finding review and then have an inadequate record before this court ultimately on an appeal, I think is an improper policy. The best position here and the avenue that Mr. Turchi has with his client is to file another 3030 motion ultimately and to litigate that adjournment. And the people would submit based on conversations that had ex parte with the court about the standards that OCA had for trials and cases, that adjournment will also be excludable. But again, that's not in front of us, not in our record here today. And unless the court has any other questions, I'll rest on the papers at this time.
I think we're good. Thank you, Mr. Day.
Thank you, Your Honor.
You got 1 minute.
Yes, sir. I am somewhat troubled that part of the respondent's argument is, well, I know this case and what was really going on was this, and it may not have been presented below, but just take my word for it. Oh, but if that's not good enough, which it should never be, the backup is, well, this is why you should defer to the court when it rubber stamps this as a consent adjournment. Plenty of cases in this court, other appellate divisions, Court of Appeals, actually have educated the lower courts pretty routinely in what constitutes consent as a matter of law, even when the underlying facts are not in dispute. Finally, the concept of having to continue to file 3030 release motions is impractical and completely undermines the rationale of the release statute. Thank you.
Thank you, Mr. Turchi. Thank you, Mr. Day.
Thank you, Judge.
Last is Primus Pacific Partners. Justice Weber is recused. Justice Owen is vouched in the case. And
we're contacting him.
He's on.
Okay, he's on. I see him. Ready to go, Justice Owen?
Ready to go.
Okay. Let me hear from Primus Pacific.
May it please the court, Sharon Corpus for the appellant, Primus Pacific. We are here today on a very different record from the 2018 appeal when this court held that the action should be dismissed for forum non-convenience. At that time, the court only had before it Goldman Sachs' affidavits for the proposition that the persons who committed the fraud had nothing to do with Goldman Sachs Group, the New York headquartered entity. The record today contains admissions by both defendant Leisner and more recently Goldman Sachs Group itself in criminal proceedings that Leisner and his co-conspirator Inc. were acting in Malaysia at minimum as agent of Goldman Sachs Group for the benefit of Goldman Sachs Group and with the knowledge and supervision of Goldman Sachs Group. That's why Goldman Sachs Group, the New York entity, entered into a deferred prosecution agreement that you agreed to take judicial notice of and agreed to pay the US government $2.9 billion as a result of conduct in Malaysia, and where it admitted that Leisner and Goldman Singapore were acting as agents of a domestic issuer. And Goldman cannot today dispute those admissions for the purpose of avoiding civil liability. It is actually barred from doing so under the terms of the very same deferred prosecution agreement. Here is the new information that was not part of the record last time that the court should consider. Going first of all to 2018, the indictment against Leisner, which came after the record was complete for the last appeal. Even in that indictment, Leisner pled guilty to criminal information that alleged that he acted as an agent and employee of Goldman Sachs Group. Goldman argues that that's Goldman Sachs Group defined broadly as including all of the Goldman Sachs entities, but in paragraph 1 of that indictment, in the record at 119, it clearly is defined as the US entity, and he admits that he is the agent of the US entity. And in any event, it makes no difference because later on in the Goldman deferred prosecution agreement, they admit that he was acting as an agent of Goldman, the New York entity. So this is Judge Owing, but when you look at there are a lot of factors that come into play when we're talking about FNC, the forum nonconvenience, decision making, right? I mean, it's just not, just having a connection alone. There aren't these transactions that are at the heart of this dispute all occur in Malaysia? I mean, in a foreign country? Or am I missing something? So yes and no. The transaction, the Eon Bank transaction, took place in Malaysia, but by people who were sent there by Goldman Sachs New York in order to cut a deal with the Prime Minister of Malaysia to benefit Goldman Sachs New York through the 1MDB deal. That's why the government prosecuted them here. That's number one. And we allege that there were meetings in New York at around the same time as the Eon Bank transaction. We allege there was a meeting in November, in November 2009, 1 month before the fraudulent representation was made to Eon. There was a meeting in New York where Leisner met to discuss 1MDB business with Goldman, with a high-ranking executive, which is believed to be Lloyd Blankfein, was at the time the CEO.
I understand that, but all these businesses that we're talking about, they're all Malaysia. They're all in Malaysia, these businesses, right? I mean, Eon was being, your client, the plaintiff here, basically saying that they didn't get a fair price, that they got the short end of the deal, right? But these are all, but they all happen in Malaysia. These are all Malaysian companies. They're all, I can't.
But the conduct, if Goldman New York arms people and sends them globally to do its business and relies on the fact that it's a global operation.
Well, that would mean, by that argument, that would mean that our courts be flooded with every single, not just Goldman, but you have Morgan Stanley. I mean, every single investment house that does global business would then mean that all their transactions that blow up ends up in New York.
But
that can't be the case, because that's just taking your argument to its logical conclusion.
My argument doesn't go all the way there, because my argument is just
it's only for your case that you wanted to go all the way. I got
nice
it.
To see you again, Justice Sawing. But
it's
my
good to see you too.
But my argument really is that there were high-ranking Goldman executives in New York were involved. There was the meeting with Lloyd Blankfein in New York. There was a second meeting in New York. Also, my argument is there was this intelligence committee that the new
Can I ask a question? This is Judge Gish. How do we know that those meetings had anything to do with the Eon transaction, or that they weren't just generally related to the business that Goldman Sachs was doing in Malaysia and Asia?
Yes. We are here on a 3211 posture on the motion to dismiss pre-discovery. The allegation that we are making is that the quid pro quo for 1MDB were the other side deals that Goldman agreed to do for the benefit of the Prime Minister. That's what we allege. We are alleging that those.
I understand that, but the documents that you now have from the Eastern District, none of them specifically reference the Eon transaction.
Not specifically the Eon transaction, but they mention other business and other projects. Let me just quote from paragraph 24 of the new Goldman Deferred Prosecution Agreement. Leisner Inc. and others used the connections to obtain and retain this and other business for Goldman. And the bribes resulted in Goldman being engaged on, quote, among other projects, the 1MDB offerings. There was more here. There was a lot more here. And this is actually a key point. I'm glad you asked me that question, Justice Gersh.
I'll give you 30 seconds to answer that.
I only need 30 seconds. There was a committee that had New York-based people on it to monitor dealings done in high-risk jurisdictions. And what the indictment states is that committee had to review and approve all transactions in high-risk jurisdictions, including for advisory deals. And that's what the Eon transaction was. It was an advisory deal that had to be approved by the intelligence group, which included New York people sitting in New York. Thank you, Your Honor.
Thank you, Mr. Corpus. Okay, counsel.
Thank you, Your Honor. Sharon Nellis for Sullivan and Cromwell. Good evening. Thank you for lasting this long for us. Plaintiffs ask for relief from judgment based on so-called newly discovered evidence gathered from these unrelated criminal proceedings. And plaintiff says that these filings show that Goldman Sachs Group, which is a New York-based holding company, engaged in a broad scheme to curry favor with Malaysian officials, and that broad scheme overlaps with the time of the Eon Bank transaction.
Well, I heard Mr. Corpus saying that they actually send their agents to Malaysia to engage in the scheme to which they pled, right?
What Mr. Corpus very carefully avoided saying is that all of the filings, all of the criminal filings relate to one MDB. They do not relate to Eon Bank. And so that leaves plaintiffs with two problems. The first is that they alleged the exact same thing in their original complaint in 2016, that there had been this contemporaneous overlapping broad scheme at the same time of the Eon transaction. And the other problem is, of course, that nothing in the criminal filings connect the broad scheme to the Eon transaction. There is not a single reference in the 227 pages they've asked you to look at, not a single reference to Eon. And in fact, plaintiffs repeatedly argue, they're quite clear that they can't connect the filings to Eon. So they ask that the inference that they have drawn from these filings, that they should be allowed at this so-called pleading stage to take discovery. But we're not here on a 30-11. We are not at the pleading stage. Plaintiffs are conflating a pleading standards with what it needs to establish to obtain relief under CPLR 5015, to obtain relief from judgment. And what plaintiff needs to provide here is new evidence that likely would have produced a different result, not a new theory that might have supported discovery if we were still before the court on a motion to dismiss. Let me just really quickly address two statements that Mr. Corpus made. The first about the DPA and the reference to the other business. If anything, the filings actually support what Justice Oing noted, is that everything here really relates to Malaysia. And the fact that there is nothing in these papers at all that reference Eon Bank and that you can't connect the two is established because these filings lay out in excruciating detail, and I would point you to the statement of facts that is connected to the deferred prosecution agreement that describe what exactly was the conduct that was directed towards Malaysia. And it talks about what it was. That whole section discusses those other business that Mr. Corpus referenced. And those other businesses are...
I just have a quick question. With respect to the 1MDB situation, I don't think there's no connection there with 1MDB, with Eon and HLB in terms of the transaction there?
There is none. There is none.
I was trying to figure out if there was some sort of connect the dots situation.
There is none. There is none. What Mr. Corpus would like to say and has said is that these happened in a sort of contemporaneous time period. In fact, there was an overlap, but the 1MDB transactions were post-Eon. So what he wants to say is, well, you could look at this, and it's quite likely, maybe possible, that this effort to curry favor included what was happening at Eon Bank. But he has no evidence of that, and what he is asking for is an opportunity to go take discovery. That is not the standard. That is not what happens when you're looking for relief from a judgment that has been entered and that has been affirmed by this court on a form nonconvenience. And I just very quickly must say, it sort of doesn't really even matter. I think what we have to do is remember here that what this case is about, let's assume everything they say is correct, that these people worked for Goldman Sachs Group, not Goldman Sachs Singapore, that in fact that there was some connection, that there was a conversation in New York that included go out and curry favor, and they decided to use Eon Bank to do that. Everything, as Justice Oing, as you said, still happened in Malaysia. Plaintiff here is a Hong Kong-based equity fund organized under the Cayman laws that alleges that a Malaysian company in which it was a shareholder was defrauded by a Singapore advisor in connection with the sale of one Malaysian bank to another Malaysian bank. And none of the alleged misconduct that they allege hurt them happened in New York. The allegation here, the precise allegation here, is that a co-president of Goldman Sachs Singapore walked into a Malaysian boardroom and stole confidential information from a Malaysian company to give to another Malaysian company in order to curry favor with the Malaysian government. That was the allegation in the original complaint. It remains the original allegation.
Thank you,
None
Ms.
of that. Yes, thank you, Your Honor.
Okay, we'll give you 1 minute, Mr. Corpus.
Last minute of the day. Thank you. So very quickly, the connection that you asked for, Justice Oing, is that we allege that the Prime Minister with whom Leisner was in cahoots, his brother was the chairperson of HLB, the company that was buying at a discount at an unfair price, and his other brother was the investment banker for that same entity. That's the connection that we allege. That's what they're recurring favor. Number two, what Goldman wants you to say is that a Leisner and Ing can be agent for just some businesses in Malaysia, but not others. It doesn't work that way. When you have an employee that you send to a different country, you don't say, oh, you're only an agent for some businesses, the one that I'm going to enter into a deferred prosecution agreement, but not others. That makes no sense, or at the very least, they would need to put something before us to show us why they can draw that distinction. And the third point is it is a 3211 standard because it was dismissed under 3211, and that's what we're trying to reopen. Thank you, Your Honor.
Thank you. Thank you both. This concludes today's virtual arguments. The court stands in recess.
Thank you, Your Honor.
Thank you. Good evening. Thank you for your patience.
Good night.